May it please, Lord, sir.
Yes.
I make a mention, my Lord, regarding item number 15.
Yes.
Election petition, my Lord. So I am filing one miscellaneous application for leave.
For?
So, for leave. For
Leave
granting leave from the Honorable Court, my Lord, for serving copy to the other council. So, my Lord, my humble submission is that since I am filing today, so matter may kindly be taken up tomorrow, provided with the other council is also agreed. Tomorrow,
Who's the other council?
Other council, Bansal, whether they are appearing or not.
Who's appearing? Who's appearing for the respondents?
The
return candidate?
Big Khadim.
You're applying for return candidate?
Yes. Tomorrow, I'm just seeking tomorrow.
For tomorrow, yes.
So I'm just mentioning, yes. I'm just keep submitting the mention, ma'am. Tomorrow, ma'am.
Yes.
Yes, ma'am.
May please, Your Lordship, I beg to mention item number 34. There's some development in this case, so we kindly pray for time for 4 weeks. Because we need to file a writ because Lengdo has been removed. So we're planning to challenge the suspension.
Just also 3 weeks on the request of the counsel for the respondent, or for the prisoner, of the respondent, as there's some developments.
Well, make a similar prayer for item number 30.
30.
Request, my Lord.
30.
30, my Lord.
And for the petitioner,
You have some objections? Second appeal.
Second appeal.
Okay, 2 weeks. Yes.
Very much.
I beg to mention item number 26. Hearing this.
26.
In fact, Mr. Ganguly is also here. So
yes, Mr. Ganguly.
Yes, Mr. Paul had given me a call that he is not available. As far as I am concerned, I am available for PC.
After 2 days? 2 days?
Next week.
Can it be on 20th?
On?
20th of July.
20th July. After.
May I please, Your Lordship, I beg to mention item number 31, Your Lordship.
Number?
31. Let this matter be taken after 2 weeks, Your Lordship.
And for the petitioner, Your Lordship.
Why? What's the matter about? G. Sangma is here.
Yes, sir. He's in the...
Regarding the 5th pay commission, Your Lordship.
Regarding?
5th pay commission.
5th pay commission? Why you don't do the hearing? It's just taking time for the sake of taking time. 1 week, 2020 matter.
2 weeks, Your Lordship.
No. I'll start fixing matters on fixed dates, and if it's not done, then it'll be to your detriment. The court will decide on the basis of materials that you produce. Because wholesale adjournment is, yes.
Much obliged, Lordship.
Yes.
This is I'd like to make a mention on behalf of KP Bhattacharya, Your Lordship. Item number 29, Your Lordship.
Why?
In some personal difficulties, if this matter may be taken after 2 weeks, Your Lordship.
What personal difficulty?
I just got
Is Aspimanta still on leave?
Yes.
Okay, 1 week.
an interim order may be continued.
Interim order vacated, correct? I'm not going to continue interim orders if we keep on seeking time.
On just 1 week, or that interim order may continue for 1 week.
1 week. Yes.
And the village, Your Lordship.
Yeah, please, Lordship, I beg to mention item number 36, Lordship. 36, Lordship. I pray for some more time, Lordship, because Mr. Ashishek has some personal difficulties. Ashishek.
What's the matter about?
With regard to the appointment of this multiple service provider, Your Lordship, in the fishery department.
Okay, 2 weeks. Yes.
And your Lordship.
Main list, item number 1.
See, what happened is matters that, in fact, the court that day did not take up the missed case.
I have not carried the main petition.
It went straight to the main
That's
petition.
why I had to fumble.
That's the only thing. So now we just take up a condemnation application. That, right, Mr. Nongri?
My lord. Why not the facts of the case?
No,
are
just
like
on a
this.
condemnation. We give your reasons on condemnation because this is the missed case for you. Because you started on the facts of the case, you see.
Yes.
So court also got carried away and decided on the facts of the case. So that's why at least on the condemnation, how do you explain the delay of
I'll start
even
from-
leaving aside the section 5 is not applicable, but
I'll start from where it started actually, that dismissal of the case.
yes.
My lord, on 3rd April 2017, there was a hearing in the lower court where one Kirman Pasha was added as a defendant.
3rd 11,017.
Third, I've not added, it's not here on record. Now, that after that petition, the petition of the Kirman Pasha was allowed by the court and added him as a defendant, which was objected by Mr. Tarian, late Mr. Tarian. I was handling that case. Then thereafter, he wanted to appeal. So I left the case.
Who wanted to appeal?
Mr. Tarian, the father of the present petitioner. I left the case, thought some other lawyer will be taking up the appeal in the district council court. Then later, sometime in 2018, I met the petitioner and asked about the case. Then he said his father had expired. So then only I came to know, sometime in February 2018. So along with him, I went to the court on 20th March 2018, filed one application for substitution, substitution of the plaintiff, this petitioner, instead of his father. With that petition, when I went there, the court informed me that then only I came to know that case was dismissed for default on 12th September 2017.
12 September 2017. Where are those dates?
12 September, 26. No, the case was dismissed on 12 September 2017.
Have you mentioned it here?
Yes, my lord.
First you said some person was added as a defendant. Correct?
Arvind Pasha, the present Arvind
Yes.
Presently one Pasha has also joined respondent 6, his predecessor. Then during that period, when the case was dismissed, the respondent started constructing some houses there in the Suitland.
So where you written on 12/9? 12/9 is dismissed. 12/9/2018, 17.
Yes, my lord.
I don't understand. If you say that Kerman Pasa was added on 3/11/2017, then the suit was dismissed on 12/9/2017. See, Mr. Bora, that is why this confusion has arisen. That could listed the matter, especially today.
1217.
See, paragraph 3.
Yes, my lord. Then thereafter, what happened when construction was noticed? This petitioner filed an application under 151 to stop the construction, ongoing construction on the Suitland. And that case came up to the High Court.
We just go to the what is in here. Okay, just come to para 3, right? Now, para 3, just see that on 12/9/2017, just read with the court. Para 3 of your page 4, para 3 of your application. Okay, that on 12/9/2017, due to the absence of plaintiff, the learned trial court was dismissed TS number so and so for default. Okay.
Yes.
Yeah. Be it humbly stated, the conducting counsel of the plaintiff in title suit met the plaintiff's son, the instant petitioner, in March 2018, and came to know about the demise of Mr. Tarian. All the time he was under the belief that matters on appeal. Now come next paragraph. Then again you go back. Then if you met in 2018, then you file a substitution application on 23/2017.
Not 17. That is a wrong
para 4.
assumption by the.
No, see para 4. This is the own application I'm reading. Then you read the application. Okay. Then you say that 9/17 is dismissed. Then you say that he died in 18. You come to para 4. Just please, Mr. Bora, come to para 4. That on 23/2017, the petition file application is the petitioner also restoration was court form get dismissed on 12/9/2017. Now you file an application of restoration before the case was dismissed. How is it possible?
No. That is wrong.
Para 4.
That is wrongly written. Actually, the petition was filed on 28 March 2018. My lord. The order is also there with the main petition, I think.
See number 4. See para number 4 in condition application.
Order passed by the court is also there.
See, Mr. Bora, please do not get the court agitated for nothing. We're just going on on the pleadings of your application. Now you see in 23,000 that petition filed application substitution. Then a restoration. case had been dismissed on 12/9/17. See your own paragraph 4. Not correct, Mr. Nongri? How will a court go on with this kind of application?
I did not apply on 20th
No,
March
see your pleadings here.
2017. It was 2018.
See your pleadings here.
I may be allowed to correct the date.
How will you correct the date? I'm dismissing it. This coronation application has been filed seeking a coronation of delay of 186 days in filing the civil revision application. Stop. A perusal of the amendments made in the application shows many contradictions which this court cannot reconcile with, which deals with the date of dismissal of the suit in the trial court, which is shown as 12/9/17 in para 3. The statement that the demise of the late plaintiff in March 2017, and a statement para 4 that restoration was filed on 23/2017.
Not 17 actually.
17, and that in the same paragraph itself that the case will be dismissed on 12/9/17. The matter not being able to be comprehended by this court, the instant application for condemnation is dismissed. Yes. Incomprehensible.
Item number 2.
Yes, Mr. Lindau.
Yes, Your Lordship. I seek instruction on the issue. Your Lordship, this is a matter related to deputation. As per the mandate that we should prefer to CAT is with respect to recruitment. That is recruitment. That is the jurisdiction, Your Lordship, as per Section 14 of the Act, Your Lordship. So for the reason I've approached this honorable court on basis of the...
Can deputation be separated from...
All service matters, it says.
All service matters in fact, yes.
Section 14.
It's under the Ministry of Home Affairs, correct?
In Ministry of Revenue, Income Tax.
Income Tax, and yours Ministry of Home Affairs, NEC.
My lord, NEC is not even read as a party, my lord. His dispute is with Income Tax Department. He said that he submitted an application for permission.
Yes, it's with your own service situation with your parent department.
As per Section 2Q, Your Lordship, service matter has been defined in the Act itself. So may I read?
Let's see the Act. Means all matters relating to the conditions of service. CV C2Q, it's 3QV 5, sorry.
My lord, to explain it. My lord, here the jurisdiction of the CAT, my lord, as per Section 14, has been elaborately described. Now the question comes as a service matter, my lord. What are the service matters, my lord? It concerns with the recruitment, terms and conditions of the service.
Because there's some order passed against you which you're seeking clarification from your department itself. Like the deputation has been refused, like permission is because there's some complaint against you.
That is what, my lord.
So that is what. So that how will that not come in an ambit of the Senate Tribunal?
That complaint about the complaint has not been informed us.
Exactly.
Nothing has been
you
informed.
have enough recourse.
Now this is parent department, my lord. Parent department is the department who has to recommend the deputation application, my lord. And there is no dispute with the parent department in regard to the terms and conditions of service or recruitment.
What do I have to say about 3Q5?
That's any other matters, my lord. Any other service matter is includes, my lord. If there is a shortlisted any matters which has not been explained in section 2 and comes under the purview of the dispute, then only it comes under 3Q, my lord. Not as totally a separate subject, my lord, for recommendation only. And that recommendation was rejected on the ground of stating that a complaint was there. But that complaint was never communicated. That was not fair, my lord.
Then you have recourse. You have recourse. The same remedy you have.
My lord, that cat also, my lord, they will be subject to entertainment of the petition application, my lord. On the ground of that, it is
remedy. Yes, but automatically.
Alternative remedy, they have to go to cat.
You take your choice, otherwise we'll dismiss it.
We have this contention, my lord, that, that this dispute is not connected with the agreement of terms.
We are not accepting your submission. This court not accepting your submission. Any other service matter, you have a dispute with your Department of Revenue, your income tax officer. Then
it's counted under the civil service, of course. But the dispute here against the complaint, my lord. Grievances is a complaint, my lord. That complaint has not been communicated.
Then we'll pass orders. You're not anything in.
No, we'll take the leave. Then we'll approach the
You have to go because this. Then you are putting your own case of detriment. I mean, like they'll go there. There's the ground to take up on maternity itself. I mean, you don't go there here. Then we have to have a hearing on maternity. It takes for the 6 months for it to get over. Yes, sir. You withdraw, or what do you choose to do? We're not entertaining it. Yes, Mr. Chanat, after hearing a summary, Mr. Chanat prays I am allowed to withdraw in celebration to seek authority before the General Administrative Tribunal. Praise aloud. Matter stands closed of withdrawal.
Item number 3.
Liberty as played is.
Item number 3.
But this item number 3, some mistake is inadvertently committed, so we may be allowed to withdraw it with the liberty to file afresh.
File afresh again?
Well, some mistake
Can't
is
correct it.
actions.
Yes. Mr. H. Saru submits that there are some inadvertent errors of corrupt interpretation, which he seeks deputy. He prays which he prays to withdraw with deputy to file afresh. Prayers allowed. Matters closed and withdrawn with deputy as prayed is.
Item number 4.
How many months?
Well, it's 10 days to obtain instructions. It's coming up for the first time. Item 4 and 5.
But, yes. Issue notice. Mr. S. sends present on behalf of the respondents. No further notice required. This is matter after 10 days for instructions. Yes. 4 and 5.
Item number 6.
This matter relates to blacklisting of the writ petitioner by the respondent.
Which by the Assam Rifles?
By the PSA. By the PSA. Also is aware, the law for compliance to the natural justice with regard to blacklisting is unique and different from the normal law for compliance with natural justice. Now, in my case, 3 show cause notices were issued to him, and he answered
issued to you.
Issued to me. Issued to me. He answered it. So 3 show cause notices purpose was served. Later on, my lord, they have issued another notice where, my lord, they did not spell out the intention of the respondent to invoke the blacklisting power. That is the grievance. May I take a lordship attention to some of the annexures? My lord, we come to page number 22. This is the NIT. This is a small contract. Page number 22, annexure 1.
Installation of deep tube wells.
My lord.
Okay, yes.
Thereafter, my lord, the acceptance letter was issued by the petitioner, page number 32. Well, page number 32, on 25th August 2022.
Yes.
My lord. And thereafter, the writ petitioner, page number 83, the period for execution of the work is for 2 months only, man. Page number 83. Page 83. Now, after signing the contract, my lord, they did not hand over the site. Therefore, he has written this.
When was the contract signed? 11th August 2022.
My lord, my lord.
Okay.
Now, page number 83, last point, number 3. Lord, can you see? Please note that the entire time of 2 months allowed for carrying out the above work shall be reckoned from the 10 days after the date of issuing of this letter or date of handing over the site, whichever is earlier. So, respondents say that the contractual period for 2 months to execute the work will be 2 months.
Will be from 21st August.
My lord. Now, with subject to my lord, handing over of the sites. Handing over of the sites. Now, here the grievance here is that they did not hand over the site because of the delay was there. Thereafter, my lord, they have issued. There was a letter.
Hand over the site?
My lord, may I just come to that point, my lord. Page number 88, my lord. What may I see? 88. My lord, this letter is written by the respondent itself to the Water Commission. May I just take para 2. With reference to the above, it is submitted that the geophysical investigation for pouring of the dirt well at PSF campus of Bling Shillong to not yet completed even after lapse of 2 months. Troops and their family members are facing difficulties due to acute shortage of drinking water in the campus. Keeping in view of the above, it is once again requested to visit the PSF campus on Bling Shillong location for geophysical investigation of the aquifer for the course earliest so that the sanctioned work can be executed promptly in order to overcome the acute shortage of drinking water. So they also admitted that they did not hand over the site because of the clearance from the Central Water Commission not yet. Thereafter, my lord, page number 89, they have issued a first show cause notice to the writ petitioner. This was on 10 January 2020.
So when did they hand over the site to you?
Till my lord, they hand over the site to me on 16 January.
16 January
2020. That is the, my lord, case of the petition.
16 January.
My lord. Now, prior to handing over of the site, they have issued a first show cause notice on 10, page number 8.
No, this is prior, this is page 89.
Page 89. Is the
That
first.
is 2023.
My lord.
They handed the site to you on
16 January.
23.
My lord.
How is that possible?
My lord, that is my the claim of the petition.
16
January
123.
Yes.
And the first show cause?
10 January 2023.
They handed the site 16-1.
Yes.
And give show cause on 10-1.
10-1.
How is that possible?
My lord, I'll explain, my lord. I'll try to explain, my lord.
Sounds absurd.
My lord. Para 2, yes. Lord, can you see? Para 2. Whereas it appears to the undersigned that by reason of your wrongful delay or suspension of work entrusted to you under the agreement referred to above has not been started yet. My lord. That is, which one they are, my lord, they are relying with or no. Para 3, my lord. Therefore, in exercise of the powers conferred on me by the aforesaid agreement on behalf of the President of India, hereby give you notice to show cause within 15 days to my satisfaction why an action under clauses and such of the above agreement will not be taken against you on account of the breach of contract on your part. Please note that in case no cause is shown by you within the stipulated period of or the cause shown is not to my satisfaction, I shall take action against you as contemplated under such. That allows my contemplation for either termination or even blacklisting, prevent me from further participation. So that was the first show cause. The next page, page 90, I've given my reply.
Let's see the letter handing over the site. Where's that?
But
we said on 16/1/23, site handed over. Where's that letter?
But the letter is not that man physically handed over, and he started the drilling on that day itself. May I just come back? The next page, Annexure 7. Now, with reference to show cause notices, I would like to inform you that after continuous discussion on telephonically and through message to executive engineer, I was not handed over the site, stating reason that physical survey has not been done by the Central Water Board, and also official person, junior engineer Mukesh, told me to license with the Central Groundwater Board, handing over letter to me, references and such, which includes for your reference, and for the reason I was not handed over the site. And in return, I am getting this show cause notice, which is very sad for us, but in any way, I request you to early hand over the site to execute the work at the earliest. So this was the letter. And the next page, 91, he has issued another second show cause. This was on, my lord, 16 February. The same content, my lord, same allegation, and he has given me 15 days. Now, before, my lord, that 15 days over, he had given me another letter, that page number 92, my lord, page 92. And may I read, my lord, this? It is to inform you that the above subject work was entrusted to you by award letter refer above, but the work is held up since 28/1/2023, and in this regard, a show cause notice has been served to you by if it never sends such a show cause within 15 days to the satisfaction of the undersigned, and the reply of the same is awaited. However, on 22nd March 2023, my letter was on 24th February. Now he said 22nd March 2023, you have been assured to complete the work, the said work, in all respect on or before 2nd March 2023 in the camper of such and such, and same was endorsed in the side order book, and you are requested to sign in the book as per rule, but you refuse to sign. As such, it is requested to complete the work as assured by you. In view of the above, you are hereby informed that if the subject works as stated above will not be completed within necessary action, completed, then necessary action would be taken as per terms and conditions of agreement. Hence, complete the subject work at the earliest and sign on the side work. So this letter was issued to me. Now, my lord, give me kindly, lordship kindly take notice that this letter was issued on 24th, and the third paragraph it says I was shown on 22nd March. But the series of contradiction, but confusion was there. Thereafter, my lord,
did you reply to this?
My lord, I'll come, my lord. The next page, page number 23. He had given me another letter again on 9 March. Page 23.
They don't know to write English. They said it's actually the promise to complete 22nd March. Anyway, yes.
And my lord, to that one, lordship kindly come to page number 94.
Yes.
Page 94. This is my reply, my lord. With reference to your such and such, I would like to inform you that I have started the work on 16/1/2023 after signing the side order book as per JE instructions within 80 feet boring where my 20 feet length of pipe, there 8 gets stuck. Again, 480 feet boring done as per instruction, and after then our casting reach at site from Guwahati, but stating some reason like thickness of pipe and its filter issue, my pipe did not get accepted by the GE, all because of the advanced sample not approved by them, and same has been replaced again from Guwahati, which really consumed more time and harassment too. Again, I started the work on such with all my 100% required material for said work with casting erection, but unfortunately pipe gets stuck on such feet, madam. Maybe reason like collapse or untoward incident later going inside,
okay.
Coming out, madam.
Where's
so this was
the order?
My lord, I'll come to that one. And thereafter, my lord, page number 98, the third show cause notice.
For one tube well.
Madam.
So much correspondence.
My lord, that is why, my lord, the grievance in the department, my lord. Page number 98 is the third show cause notice. The same content of allegation, 15 days given to me.
Yeah,
and page number 100, before expiry of the said period 15 days, they have issued another letter. Page number 100.
Yes.
Page number 100. And 101, my lord. Right, just the last point 5, may I read out, my lord. Keeping in view of the above, I understand taking a lenient view, providing one more opportunity to complete function the above well, in all respect by 8 May 2023, failing which agreement of work will be terminated. So this is the last notice given to me. So if I don't complete, my lord. Thereafter, my lord, there were communications, and later on, my lord, they have given the impugned letter, my lord. That is page number 109. 109. May I just read out with lordship permission? This was issued on 27th June. As approved by competent authority, firm MS Capital, such, Shillong is hereby debarred from participating in tenders of PSA Meghalaya Frontier and other command headquarters for a period of 3 years due to poor performance in order to delay and lack of interest in execution of the work. So I may agree with this, my lord. I'll place 2 decisions to fortify my argument that this is not in compliance with the requirement for issuing notice.
Yes, Mr. Dr. Modi, what do you have to say?
Well, it appears that he has not completed the work that was assigned to him, my lord.
No, but what about the discrepancy in the dates? You can't make out head or tail.
My lord, that of course, my lord. But I'll have instruction on the final affidavit, my lord. 2 weeks time is given.
Let them come instructions.
But in the meantime, Lordship may stay the impugned, because I have 3 contracts we have signed with the same department. They are not taking any action because of this, relying on this. Since my friend is seeking for 2 weeks.
No, we still have to. Paramphasai, I don't see any case as yet for staying of the unless let them come
If I
instructions.
just
1 week.
only one judgment, madam, only one judgment, that will be very clear. The judgment.
Yes, okay. What judgment?
2014, my lord. But before taking a blacklisting action, madam, I have flagged with Lordship, Lordship convenient, para 19 and 20. The flag one, Lordship, can you come with me? This regard to blacklisting matter. Content of show cause notice. The central issue, however, pertains to the requirement of stating the action which is proposed to be taken. The fundamental purpose behind the serving of show cause notice is to make the noticee understand the precise case set up against him, which he has to make. This would require the statement of imputation detailing out the alleged breaches and defaults he has committed, so that he gets an opportunity to rebut the same. Another requirement, according to us, is the nature of action which is proposed to be taken for such a breach. That would also be stated so that the noticee is able to point out that proposed action is not warranted in the given case, even if the default breaches complained of are not satisfactorily explained. When it comes to blacklisting, this requirement becomes all the more imperative, having regard to the fact that it is harshest possible action. The High Court has simply stated the purpose of show cause notice is primarily to enable the noticee to meet the grounds on which the action is proposed against him. No doubt, the High Court is justified to this extent. However, it is equally important to mention as to what would be the consequence if the noticee does not satisfactorily meet the grounds on which an action is proposed. To put it otherwise, we are of the opinion that in order to fulfill the requirement of principle and natural justice, a show cause notice should meet the following 2 requirements. 1, my lord. The material grounds to be stated on which, according to the department, necessitates inaction. Particular penalty action is proposed to be taken. It is in this second requirement which the High Court has failed to omit. We may hasten to add that even if it is not specifically mentioned in the show cause notice, but it can be clearly and safely be discerned from the reading thereof, that would be sufficient to meet this requirement. Now, for blacklisting and relying on this matter, another judgment which is more clear. 2020 judgment. Para 25. The same lordship may take para 25. I flag it. It says, the mere existence of show cause in the bid document, which is mentioned blacklisting as a bar against eligibility, cannot satisfy the mandatory requirement of clear mention of the proposed action in the show cause notice. The corporation notice. So
you mean to say that because they have not mentioned blacklisting in the show cause notice, that is technically incompetent?
Yes. The same, this High Court, these judgments also, they issue show cause notices, but the intention of the blacklisting was not given. Therefore, they got into
Mr. HSC Counsel, Sister Basu, issue notice, Mr. Dr. N. Motika, DGSI is with so accept notice on behalf of all the respondents. No further notice called for. We list this matter. We listed on Thursday. You come instructions. This is matter on Thursday. That is the 13th. Then a DHA had come instructions for hearing on interim prayer. Petitioner.
Item 7.
Lordship, respondent number 1 and 2, they have filed the show cause, but now respondent number 3, they haven't filed.
Why show cause?
Show cause is the condemnation.
Yes. Now, what is the objection?
Only respondent.
I need 1 week time to file my objections.
Okay. It is noted that the Mr. HR who has entered appearance, he entered appearance when? You have asked for 2-3 times. How long is delay?
My lord is already ready, but there was signature on the investigation.
In this final opportunity of 1 week's final 1 week's time as a final opportunity is allowed to Mr. Sarna for number 3 for objection to condition application just thereafter. Fine, Lordship.
8.
Please, Your Lordship. Your Lordship, my instruction is that Your Lordship, the settlement is still going on, Your Lordship. Now that matter is taken up by the MP, Your Lordship.
Your Lordship, on 2 occasions they had asked for time regarding the stating that their settlement. However, Your Lordship, we had received instructions, Your Lordship, and the department is not aware of any settlement, Your Lordship. Yes,
That was my instruction, Your Lordship.
Yes, you have instructions, yes. What's the matter about?
Your Lordship, this condition of issue for appointment in the Agriculture Department.
For appointment as?
Appointment in the Agriculture Department, Your Lordship.
Have you filed an affidavit?
Yes, Your Lordship, we've already filed.
No, we listen for hearing.
Okay,
Your
Lordship, I have just pray, Your Lordship, that I have one document, Your Lordship, which I'm going to file, Your Lordship. Please allow me to bring that on record, Your Lordship.
But you want to file a joint, Mr. Nyota. How can you file another document?
This is
very important.
Yes, sir.
Let us see what document is it.
Unfortunately, Your Lordship, I have only one which is not clear, Your Lordship.
Advertisement for nursing and midwifery?
Yes, Your Lordship. In this notification, Your Lordship, there is no age bar, Your Lordship. Those who possess a certificate. So in my case also similar, Your Lordship, after holding the diploma, Your Lordship, but my age is not considered, Your Lordship.
The age bar limit 35 years. And for possessing A&M certificate, there is no age bar. I would know it. You can just bring in the course of hearing. Just take down Mr. D. Nyota's. Though Mr. D. Nyota submitted that talks of settlement are going on. Stop. MS Ailingwa today has produced a letter dated 18 May 2023 indicating the fact that there are no talks of settlement. In review of the matter, this is matter for hearing in usual course. And so on so.
All right.
Obliged, Lordship.
You give the letter to him. Let him show it to his clients.
Item number 9.
Where's the senior government advocate?
Please, Lordship, I'm appearing on behalf of the state respondent. I'm appearing on behalf of the state respondent.
Yes, what do you want?
Actually, there's Madam Angela is not, due to some personal difficulties.
No, where's the instruction? Doesn't matter. It's G is not there. There are how many? Hundreds of panel advocates now?
We pray for some more time, my lord.
10 days time was given 26/6. How many times have you taken for obtaining instructions? How many? Again, we have NG Shella, the present court today for some time. It is noted that on 26/6/2023, the state respondents were directed to obtain instructions, which have not been forthcoming till date. This is a matter after 1 week. Yes. By that time, you make sure the instructions are there. Yes.
Item number 10.
May it please your lordship?
1 second. 5, 6, and 7. You appeal for whom?
We are praying for item number 10 and 11.
No. First comes item number 10. You appeal
8 and 9.
You are appealing for which respondent?
Respondent 8 and 9, your lordship.
Okay, they're not concerned with you. Yes. Not filing affidavit.
We are finding, but the difficulty is we have been trying to communicate with the management. I think
we'll close it. Yes. You are appealing for?
Yeah, on behalf of respondent number 4.
You already filed.
We have already filed.
State's filed.
Another state has already filed.
And
Therefore, respondent number 8 item number 11.
okay, wait then, number 9. Yes, Mr. Chanda, appearing for 5, 6 and 7. To tell me, by order dated 12/6/2023, this court has recorded that if the affidavit on behalf of 5, 6 and 7 was not filed within the stipulated time, the same would be closed. Stop. Today, Mr. Chanda, appearing for the said respondents, submits that they have been unable to file the said affidavit. Accordingly, filing affidavit on behalf of 5, 6 and 7 is closed. So the court are respond. All the other respondents have filed the affidavits. This is a matter for hearing. Yes. And 11?
11, IPF the state, they also have already filed our affidavit.
Yes.
And 11?
Your Lordship, we are appearing for respondents 9 and 10. We have already filed our affidavit, Your Lordship.
4? 1 to 3 file. Yes. You are appearing for? You already filed, yes. This is a matter for hearing. The pleading is complete, this matter for hearing. But I don't know, that is correct to item number 10.
My lord, yes, 10 and 11 is same school,
Yes.
my lord.
Together with something.
But number 11, 5, 6, 7 are still not served, my lord. We'll take
Not
test
served?
of- Not yet.
Oh, yes.
We'll take first test, my lord.
No, probably petitioner directed to take fresh steps on respondent 5, 6 and 7, yes. Not police for hearing. Just to get item 10 after 2 weeks for service report on 5, 6 and 7.
12. Item 12.
May I please, Your Lordship? My Lord, we have filed our affidavit on 30th.
Lordship, I
What
pray
about
that
4 to 8? Fine. What's the matter about?
no, Your Lordship.
No, my Lord.
Small matter. We can finish it now.
I doubt, my Lord. Record will also be required. My petitioner is appearing for the petitioner.
Recently, the private respondent filed the affidavit in opposition, Lordship. I got just before yesterday. Let me just
file
go
a
through.
joinder?
I got I'll file a joinder, but
with the P4 praise forms allowed to extend for a joinder the affidavits filed by the respondents. Is thereafter and so and so.
Lordship.
13.
What's the Lordship?
Lordship. My lord, here I have state respondents, my lord, which I'm representing. I have not filed my
1 to
affidavit.
5 and 7.
My lord, yes.
Have you filed?
No, my lord, I have not filed. I have sent my affidavit for approval and
What about
necessary.
6 and 7? You appear 6 and 7.
For 7, Your Lordship, we are yet to file our affidavit. Kindly allow us 2 weeks.
What about 6? Service 6 is complete.
Yes.
Yes, Mr. N. Basumatri submits that the service affidavit has been filed indicating service of notice to respondent 6 and 7. Your name? Sorry?
Pisuna.
Yes, sir. MS, next paragraph. MSP Sunat entered appearance behalf of respondent 7 today.
Colleague here is appearing only for 7.
Number 7.
Only for 7.
Only for 7.
Or then you entered last time also you asked for time. Yes, thought me what thought piece none appeared for respondent number 6. Next paragraph, MS R only for 1 to 5 and so and so shall pay for further 2 weeks time to file affidavit. Praise allowed. 2 weeks time and listen so and so.
14.
Listen so and so.
Lordship, this matter appears to be merge with the order passed by the Honorable Division Bench.
Yeah.
In writ appeal number 5 of 2023 or 9/6/2023. More particularly, para number 5.
Anyway, we'll close it in view of the order dated 9/6/2023. Passed with appeal number 5/2023. This matter has been done in structures. One is stands closed. Disposed of.
That was disposed of with the writ appeal.
Oh, in view of the order so and so, so this matter is disposed of.
Yes.
Much of.
Obliged.
15.
Disclose disposal.
15.
Lord, 15 that may be taken up tomorrow, my lord, as I have filed.
As prayed this matter tomorrow.
Lordship, only one aspect, if I may.
Yes, Mr.
I believe on mentioning the petitioner, election petitioner has sought leave to file a petition tomorrow. I'm opposing the grant of leave because ultimately today what the position is that the election petition could not be filed as on tomorrow. It would be hopelessly barred by limitation. The petitioner may file whatever they desire.
No, you can file.
yes,
they can leave the court to file.
Yes,
I mean, it'll be subject to consideration, Mr.
Yes, yes,
Sai.
my lord. That has to be
It's
considered by the
not
honorable
a question that
Yes,
one
yes.
leave that the application is allowed.
Yes, yes. That makes sense.
Lordship may then, subject to our objections.
Of course.
Yes, yes, no problem. No problem.
Yes,
No problem. No problem.
Let's listen tomorrow.
Yes.
Whatever objections
Together,
you make it
together.
tomorrow.
Together along with the miscase.
16.
But here the respondents were required to file the objection.
Yes, we are, Your Lordship, we are for respondent number 4. We are yet to
What
file
about
affidavit.
MS and Raji?
Please, Your Lordship, I'm appearing for respondent 1 to
I know, 1, 2, 3.
I am prepared, Your Lordship, 2 weeks time to file affidavit.
Already given you time. Bar limit. How many days delay?
Delay has been condoned already.
Condoned, okay.
We filed by way of abundant precaution.
2 weeks for the time granted the respondent to file objections. Yes, there
Your
are.
Grace, Your Lordship.
17.
Fresh matter this one?
May it please, Your Lordship.
It's a fresh matter.
Lordship, this is application for the modification and reviving of the review petition number 19 of 2019, Lordship.
Why reviving? What happened?
Lordship, this review petition 19 of 2019 was disposed of by White Order dated 27.
Where's that order?
Annexure 1, Lordship, page number 22.
Finally, review.
Yes, Lordship, the review petition was pending before this honorable court, but by White Order dated 27/10 of 2021, it was disposed of, stating that the respondent has condoned. The respondent has condoned.
The artificial breaks.
Yes, artificial breaks and the period prior to the regularization of the service of the petitioners. However, Lordship, therefore the learned counsel, the senior learned counsel of the petitioner has requested that this honorable court to matter be closed. But however, Lordship, this order dated 7 September 2021 passed by the respondent have never been implemented, and the petitioner.
Then you file a fresh petition. Why filing review?
Lordship, we are also seeking for the modification of the.
No, why seeking review?
Because Lordship,
it is not a please, Your Lordship. It is not a review. Rather, it is an application for recall of the order passed in the review, Your Lordship. In fact, Lordship, this petition, in my humble and respectful submission, would not be maintainable. Lordship, kindly come to page 1 of the application. Lordship, the CPC is not applicable in a writ proceeding. An application filed under section 152, 151, Lordship, this in my humble.
Your grievance is that this certain order 7 September has never been implemented.
Yes, Lordship. Lordship, the thing is that.
Where's that order dated 7 September?
It has not been enclosed.
Enclosed?
It has not enclosed, Lordship.
It has been enclosed. See, we can't go on with this kind of application. Now you're saying that you're seeking modification of the order because the 7 September has not been implemented. You've not annexed that order also. You don't have the communication with you.
Lordship, this was in fact suggested by, filed by the learned counsel. So learned counsel was out of station; he has to go. So I have to.
Otherwise, you examine it again. Otherwise, you just praise without praise the matter after 1 week due to the unavailability of Mr. Yubin.
Yes, Lordship.
Apply, Your Lordship.
18. 18.
Lordship, may I please, Your Lordship? Lordship, I'm filing an application under Order 7, Rule 11, Lordship.
So you want to objection?
Cause a show cause moment. Will cause a show cause to the 711.
Yes, seen the application as a 711 filed by the return candidate.
Returning candidate, Lordship.
Returning candidate stuff. Mr. S. Thapa, election place for how much time?
2 weeks only.
2 weeks time to file objections to the application under Order 7 to 11. This thereafter and so on.
Highly obliged, Lordship.
19.
Please, Lordship. We were required to file an affidavit in this contempt. We filed it on the 7th.
It's been filed. Complied.
No, there has been. It's not a case of non-compliance, my lords. But what's happened is, pursuant to Lordship's order of 7922, gratuity and leave encashment, that amount was released. That totals to about 15,28,222. That has already been released. What has been withheld is a sum of roughly about 13 lakhs, which is an annual increment. That is on account of the pendency of a departmental proceeding. That is scheduled to be closed this month itself.
Okay, then why contempt?
No, Lordship, because
Did you disclose the fact that the departmental proceeding pending here?
They have not disclosed.
You have not disclosed it.
in the writ petition.
No. Where in this contempt you disclosed it?
In the contempt we have not mentioned, Lordship.
Yes.
In fact, he was a driver who met with an accident in Boko in Assam sometime in 2009, killing 2 people. And the MSC tribunal in Kamrup directed us to pay about 9,26,000 in total. So this 13 lakhs amount was retained.
Yes.
With the intention that in case he's found guilty, that amount would be forfeited. That's the only limited purpose, my lords. There was no intention to violate the orders of the court. Otherwise, a total amount of 15,28,000 plus has been released.
Yes, Mr. SN submits that to amount of how much?
15 lakhs, 28,222.
20,000 also has been released to the petition as that is the part of the
no, that relates to gratuity and leave encashment.
And leave encashment, but some amount has been withheld due to the fact of a pending departmental proceeding against the petitioner, which on completion, which is
scheduled to be completed this month.
Which is scheduled to be completed this month. The said amount, the same will be decided accordingly. So you want to keep contempt pending? No point.
Lordship, after 2 weeks, because
So submit, that's a different cause of action.
Yes. Any outcome of the said proceeding will stand on a completely different footing. You find that through the matter, nothing remains for decision in the contempt application seems closed. If you withhold it, you have to come by writ again.
Lordship. I'll leave it.
20.
Yeah,
Have you filed affidavit?
Lordship is not necessary. In fact, I made a submission last time, Your Lordship, that this writ petition, in fact, is not maintainable and covered by a judgment passed by this honorable court, Your Lordship.
Yes? If they can file an affidavit, because all we want to do is first
Lordship, on the next...
Just show us a score sheet. If you don't have also, you can mention in the affidavit, then we can go ahead with that.
He says it's on law only. And it's covered, like your case is covered by the judgment.
In fact, if Your Lordship is pleased to kindly come to the order dated 27/4/2023.
27/4?
27/4/2023.
Where's that?
Lordship, passed in the writ petition, Your Lordship. May I read it?
Oh, sorry.
I have the copy. I have the copy with me, Your Lordship.
No. 27.4.
Lordship,
Here only,
yes.
pass in this repetition.
Yes, in the writ petition only, Your Lordship, yes.
Yes.
Lordship, it says that that the case is covered by the judgment dated so and so rendered in the BPC. Mr. So and so for the petitioner pray that he may be allowed to examine the same prayer is allowed. So
have you examined it, Mr.
Then thereafter, Your Lordship,
Yes, Your
he
Lordship.
wants.
Applicable. Which is how?
The thing is that, Your Lordship, there's one judgment which passed by this Honorable Court by Your Honor itself. This judgment was passed on the 17/8/2022, Your Lordship. It says which this observation made by this court. Now this judgment is basically about the age bar. I am not coming against the age bar. This judgment covers about the age bar, talks about the age bar. I am not after the age bar.
Speak to the mic.
Yeah. I am not I'm not challenging the age or anything out here. I'm just simply, what I want is, I want my score sheet. They say that I have my score sheet is tampered. And I have my reasons why I'm coming here, but only after what I'm asking is just a score. Just give me the score sheet so that I can see. If the state can just provide by way of an affidavit, I can see, then we can go ahead. I have something, at least my chance, my last chance, which I can come, because
but
individually
they're like flogging a dead horse, these teachers' cases now.
Yes, Your Lordship. Because
because you see, the thing is that the committee has dealt with everything, and again, if petitions keep on coming, they try to pick out. But then that the court will not go into nitpicking again into these.
Yes, I understand, Your Lordship.
And because every candidate's case has been considered, correct?
Yes, Your Lordship.
Then,
if that's what, Lordship. My only prayer is this: we can file a counter affidavit, and then finally it can be disposed of.
You say that you denied national justice. You're not heard. You have to see the score sheet.
Yes, Your Lordship. That's what I'm saying.
Because to fresh consideration, there's no question.
If I may be allowed to.
Yes.
If I may be allowed.
See, even if you are that,
yes,
and you will not go there. Yes, Mr. Shulai.
Lordship, kindly come to page 55 of the writ petition, Your Lordship. That is the consideration made by the High Court Committee, Your Lordship. Yes, page 25.
Something of 55.
Lordship, yes. The name of the writ petitioner, and that is with respect to the name of the petitioner.
Yes.
Lordship, kindly see towards the kindly see the finding, Your Lordship. Secured so and so to ask the selection board awarded her 10 marks under experience and teaching, which carried maximum 10 marks.
You have this finding itself. How do you expect the court to? What score sheet you want?
Your Lordship,
because you've given additional marks also.
Yes, Your
and you're found to be tainted.
Yes, Your Lordship.
Then if Lordship kindly come to page 50 of the writ petition.
Yes.
Lordship, kindly see the academic. Lordship, kindly come to serial number 3. Dot number 3, Your Lordship. 2 marks. Lordship has gotten.
Where's that?
Lordship, kindly come page 50.
50.
And then Lordship, kindly see non-variable mark score, then academic. Then Lordship, kindly see 1, 2, 3, that dot, Your Lordship. Yes. So she has been keeping this mark for 2 marks, Your Lordship, which is not entitled because she is a third division pass, Your Lordship.
Your Lordship.
That is the finding of the High Power Committee, Your Lordship. In fact, Your Lordship, in the judgment and order dated 17/8/2020, Lordship was pleased to consider this aspect of the matter. If Lordship kindly have at page 20, paragraph 20 of that judgment. Lordship, I have. Yes. Whether Lordship is having that judgment. Lordship, kindly come to para 20, internal page 18. In the considered view of this court, with the grant of the liberty and the subsequent proceeding before the committee, wherein there is our examination and recommendation made, there are no further course of action has occurred to the petitioner to re-agitate for re-examination of the matter on the condition as raised. So, Your Lordship, the matter has been considered by the HPC, Your Lordship. They have come to this finding, Your Lordship, in my humble and respectful submission, Your
Yes,
Lordship.
Mr. Wajri, what remains?
Your Lordship.
How now? Suppose
Yeah.
suppose your score sheet. What do you do with the score sheet? The committee is found. You see the page 55. You read it. It's very damaging.
Your Lordship, at page 50 itself, since I has taken us to page 50, third division. If you look at the
No, we don't.
that third division, he was allowed
You see page 55.
Yes, yes, Lord.
Okay.
Yeah.
So you just read. I will read together. Okay, for your satisfaction. You second paragraph. Second paragraph of the third column. The committee examined the documents submitted by the candidate. She passed on HSLC in 2016. She passed SC 936 and passed SCT. As per notification date 24 in 2008 under clause 1C, person successfully completed the course of training for so-and-so, and obtained so-and-so, outside eligible to apply. The candidate passed SC second, third division 986 and obtained diploma in elementary teacher education with roll number non-port so-and-so and secured further division. For SSC pass, no marks. For SAT pass, she gets 10 marks. The election board awarded her 10 marks on the experience and practice training ability, which carried maximum of 10 marks. She gets no marks on the education qualification, but she was given 2 marks in class 12 pass in third division, which is irregular. Also, her marks on the experience. See, they're very detailed. Where's that ending part? Where's the second page?
Page 56, Your Lordship.
No.
There's no, we don't read this much.
Here only. It's
Yes.
at page 55 only, Your Lordship. So there is a clear finding of the HPC, Your Lordship. They are also constituted by the Honorable High Court.
Mr. Wajri, you take a choice. Either you withdraw or the judgment 1711 will cover your case.
Okay.
Should you withdraw it? You would, otherwise, you will not reopen.
All right.
You withdraw it?
Withdraw it.
Yes, Mr. D. Waji submits that on examination. It is found that the judgment dated 17/8/2022 passed by this court in Direction 189 of 2021 to substantially cover her case, the case. As such, he prays that we be allowed to withdraw the instant application.
Apply, Your Lordship.
Matter stands proof of withdrawal.
21.
May I please, Your Lordship? Your Lordship, I humbly pray 2 weeks' time, Your Lordship, to file affidavit.
None of us with correct respondents. Served. It's served.
Yes, Your Yes,
Served. Yeah. Though the correct respondents 4 and 5 have been served, today also none appear to be have stopped. MS Endraji, Council respondent for praise for further 2 weeks' time to file affidavit. Prayers allowed. This is matter on so and so.
Much obliged, Your Lordship.
22.
May it please the Lordship, we are asking for further 2 weeks' time, Lordship,
Why?
to file our affidavits.
How many times was the first time?
This was filed on 11th May, Your Lordship. I think this is my third time
MS
after the
yeah.
motion.
Let AG praise funds allowed. This is by so and so. For the 2 weeks' time.
Further 2 weeks' time. Lordship.
23.
Wait, please, Your Lordships. Well, as per Your Lordship's direction on the last occasion, my Lord, I was required to file an affidavit in reply within 3 days. I have done that, my Lord. The only thing I am just pointing out to Your Lordships, on the last occasion on a submission made by my learned friend that he is not representing MPSC. And
This is a final matter.
Yes, Your Lord. MPSC and the managing committee. Lordship wanted me to take steps, including the dusty service. Well, I don't know. Unfortunately, that part is not reflected in the last order. So, unless reflected, my Lord.
Mr. Khan, what have you done in this matter? What's the respondent done?
My Lord, we have just received the copy of the rejoinder, my Lord. We are yet to go through.
Are you allowing it to fly like this?
My Lord,
setting a very good example to other principals.
But in the meantime, my lord, two interesting developments. Recently, I have been, my lord, this is affiliated to ICSC Board Delhi. As an acknowledgement of my service, I have mentioned it in my affidavit. I have been shortlisted, included in fact, in the panel of inspector, my lord. That is a big honor. As an acknowledgement of my service. Very recently, last week it happened.
We're not going into the service.
But anyway, my lord,
we're
only thing your lordships, whether
we just go into the executive action that's been taken.
Exactly,
If you find an officer or someone to be errant, you let them work for 9 years, and when you have 20 days to retire, you start taking action.
Only after one incident. I have narrated it very clearly, my lord. All these things started after the incident. Now, my lord, only thing your lordship, if your lordship desire, my lord, that I should take steps, my lord.
I think no need to take steps, Mr. Singhan.
My lord.
Your materials should suffice.
My lord, only
this managing committee. I don't know.
Managing committee and MPSC, my lord, I cannot represent. 4 and 6, my lord.
Mr. SN has brought to the notice of the court that though observations were made for service of notice on the respondent's number,
4 and 6, my lord.
4 and 6.
4 and 6.
The same was not recorded. Accordingly, the petitioners will take steps by today itself for effecting service on the said respondents 4 and 6 by personal service. Next parameter, N. Sincon submits that as he just received a copy of the rejoinder, he may be given how many days time?
1 week time.
1 week's time to examine the same. Since it
is a dusty service, by tomorrow, your lordship, 48 hours, lordship.
By tomorrow? Okay, by 48 hours.
Interim order will continue.
Interim order will continue next date. He'll die now. It's about to expire now.
All right.
Hearing? Hearing item 24.
Lordship, these two analogous matter, 24 and 25, are fixed for filing retention options.
By the bullet points?
Yes, on the main points. I have filed it.
You ready?
Lordship, yes. I'll file it now, your lordship.
That matter regarding SAD?
Lordship, yes.
Yes, council parties have filed the bullet points. Accordingly, the matters reserved for judgment.
Apply, your lordship.
27.
May I please, Your Lordship? Matter was heard at length, but thereafter Your Lordship was pleased to direct translator of this office to get some copies to be translated.
Where are the translated copies?
These are there, a part of record, and I have also obtained LC record. It is with us.
Philip. Aye. Clear. You see the translated copies?
I've gone through it.
Quite long. You've got copies?
Yes, yes.
Translated copy. You see.
We have received some record, not a translated copy. Some record we have received.
Then Garo.
Yes.
So those have been translated, correct?
Where do you receive? You received?
It's there.
Flag mark is there, Your Lordship.
It's only just some.
I cannot understand. What was the proceeding?
This number pink flag on the beginning.
This one?
Yes, Your Lordship. This is. This is page. This is annexure 1, page 16, I think. So.
Yes, yes.
Yes, and then next page is 17. Then next page is page 20.
Yes, on Garo.
All Garo. So these documents are translated. So.
No, but only how many documents were translated?
Not only 4 documents, Your Lordship.
But in the translation, there's so many documents.
So for one document.
Annexure 1, okay, that page 16, correct?
Yes.
Page 16, 17. Then annexure 2.
2 also. Page 20. Page 20. This is NOC from. For transferring that no objection in transferring the land in the name of the petitioner. This is the thing. It is dated 10/6/2004. The left hand side it is signed
14/7/15.
40. I think, Your Lordship, this is exhibited on 14/7 because on the left hand side it is written 10/6/2004. Signed or something written, can't read also. The left hand side below the witnesses.
No dates given. That's 10/8/2004. Service.
Service.
Then page.
Lecture
2A.
And 2A. That is also same. That no objection.
It's 20.
And then. To page 22.
Then where does this come from? This page 33 again.
33. So I am. Page 33 is the annexure 4, Your Lordship. Page 33, annexure 4.
Yes.
This is given by the judicial this is given by the village court, Your Lordship. Village court has written a letter to the judicial branch of the Garhwal Autonomous District Council for cancellation of the patta of the petition.
This is for cancelling the patta?
Yes, they have written. This is the village court has written to the judicial branch for cancellation of patta. And in the last line here already It is written, we the village court therefore cancelled all the pattas and passed order that the pattas be made in the name of the respondent, that is Bensila Sage Sangma. The only thing is that you
says that in such circumstances, since the patta is transferred or if it is village land, we the village court therefore cancel all the pattas and pass order the pattas made in the name of Simiti Bensila Sangma.
But your lordship, petitioner is in possession since 1991-92 after the death of the original
10/12/15. This is.
And petitioner filed.
What about 10/12/15 is what? That's page 37.
Page 37. This is continuation of page 33.
No. Page 37 is a different annexure. Page 37, they show prisoner talk different judgment order
That
of
is
the court.
report by jury member. One. That is from village court only.
Then if I don't understand this, they submitted judicial branch on 10/12/15.
15 for cancellation of patta.
Then same day 10/12.
Same day they have already cancelled and again they requested the judicial branch of the.
So the same day the order was passed.
Yes, your lordship.
Yes. So the final finding of all these proceedings that this Bensila Sangma, you are representing her.
Lordship.
Is the rightful owner.
Lordship.
As per the village code of.
As per the village of court, as per the village court, and also by the judge of the district council court.
Okay.
So in the district council court, judge of the district council court have passed a detailed order. Yes, framed the issues, recorded the evidence, everything. Whether even each and every issue has been detailedly discussed in the judgment, lordship. Lordship, if I may take this, there are 5 issues. They have framed the issues, and then thereafter, your lordship, may I just say, your lordship, this is a revision, your lordship. Well, lordship, on the division bench of this court, this honorable High Court, have passed an order now where it says that in the revision there cannot be reappreciation.
No, there cannot be reappreciation.
Yes,
that was whether the order is irregular or without jurisdiction. Where is that? Where's the finding of that court?
May I take you to that page 74, 74 of the civil revision petition number 2 of 2019. It start with page number 69, annexure 8, lordship, annexure 8, and then the annexure 8, and the issue which they have discussed in detail is relevant. Page 74.
Let's go to the other order of judicial officer. Where is it?
Other order of official lordship, prior to that, they should have enclosed in the petition, but it is page 54. Page 54.
He set aside the village court order.
Lordship.
Yes, your lordship.
Against
whereby the Benilish Sangma was given all the property.
Yes, your lordship.
Now let's go that fair.
No, your lordship. Only thing is that your lordship, because the subordinate district council court has cancelled, set aside the order of the village court because she said that law of limitation is applicable to the whole state of Meghalaya, because as per division bench of this one.
Even the law of limitation, everything has been discussed in detail, and
no, this order
and
was
in fact, lordship, may I just complete. In fact, the civil revision petition number 2 of 2019 itself, it is rendered infectious because by this order, your lordship, they have the office of the government council have passed an order cancelling the atta of the petitioner, lordship. There is an order, and he have challenged, but this was, there is no stay in this one. This they have challenged the order dated 25 June 2019 in the writ by way of repetition. However, they should not have in the repetition, but even there is where
the repetition disposed of?
No, it is pending.
number 20.
Stacked together, number 20. Okay. And even this, there is no stay. To that effect, I would like to bring to the notice, lordship, make to submit your order 41, lordship, order 41 of CRPC the Rule 5, it says that an appeal shall not operate as a stay of proceeding under a degree or order affiliate from the except so far as the affiliate court may order nor shall excusation of the degree we stay by the reason only
Mr. Salma, it'll follow because the substantive dispute is in this civil revision, correct?
No, check.
Because on the basis of the judge's counsel court which allowed the appeal, allowed your appeal, correct?
Lordship.
So the pata was cancelled. Is that correct?
Lordship.
So that follows this.
And moreover, there is a clear judgment from this from the division bench, Your Lordship, where in the case of acting sim of Hima Milliam versus KHDC, I think that video Kail that or detail has been discussed where the petitioner has to only challenge the illegality of the order passed by the judge of the district council, because here we cannot reappreciate evidence. As per this judgment, he has to only the loopholes, illegality or certain procedures.
No, that's the court's aware.
Here this is the revision petition.
No, this is the confines of revision. This is here. Yeah, it's okay.
And Your Lordship, may I just, in brief, Your Lordship, I just...
No, let's see, I want to see the order of the judicial officer. On what ground was the village court order set aside? Where's the relevant part? Because it's not a revision against concurrent findings, you see. What has happened here is that firstly, your village court decided against you. You filed you didn't file an appeal.
Yes, I am
filed an appeal, and then what happened was the
subordinate
district council court
yes,
allowed your appeal against village court's order,
yes,
and an appeal again that is like amounting to a second appeal. This the matter was decided against you, correct?
Yes, Your Lordship.
Yeah. So now is the operative part for judicial officer's order.
Yes,
This subdivision council court.
it is from the beginning only, Your Lordship, because he said that.
No, where is the operative part? Whereby?
Yes, last page
the
number.
short order. Okay,
55.
read it.
55. Your Lordship.
Read it.
Page 55 and
54.
56. Yes.
54 Annexure 5.
Yes, Your Lordship.
Read it.
Yes, Your Lordship. The civil appeal between supra-mentioned parties is pending for final order. By the order dated 10/12/2015, the lower village court Mukdangra within Garabada PS, now under Southwest Garo district, ruled in favor of the respondent as regards the suit pen parcel of the land. Something spelling mistake. I am not delving into all the attending factual circumstances of the case, because as appellate court I am first to satisfy myself as to whether the lower court while trying the suit followed the due procedure or not. For any civil court, the procedure to be followed is not only the provision of Code of Civil Procedure CPC but also the provision of Indian Limitation Act. No civil court can ignore the provisions as enshrined in the Indian Limitation Act 1963, after all as laid down in Bidyacharan versus Khubchan 1964 SC 1099 by the Supreme Court. The provision of CPC and the Limitation Act are in part material, thereby meaning that provision of both the CPC and Limitation Act are to be applied together. Let me point out this legal aspect also, that whether the opposite party raises the issue of limitation or not, it is the duty of the court of the first instance itself to scrutinize whether the suit has been filed within the prescribed period of time.
Shaman, inside the courtroom. Huh? Huh? कैसा अंदर कैसा आ गया? वो बोला वो बाहर निकालो.
It's been long time. It has been long time. He's making noise. Since that time we were
pass an order that you adopted as a pet. Is that all right? You don't like cats?
No, I'm not saying that, but we could hear the sound from the beginning.
Must be hungry or something like that. Hey, mat karo. इस क्यों हाफ ब्लैक दिया है?
ठीक है ठीक है.
It's gone under the committee table, I think. Is it ill or something?
No.
Be petrified, yes.
May I please, Your Lordship?
Yes.
The opposition part is actually
No,
page 2.
let her read.
Lordship.
You sit down for a
Lordship. Lordship.
Yes.
Suit has been filed within the prescribed period of time or not, and such a legal mandate is manifested in Section 3 of the Limitation Act. Now, briefly, let me call out the factual contours of the instant case. The respondent furnished one rejoinder statement, and at para 4 of this rejoinder statement, she has inter alia asserted, in the year 1994, Prince On C.H. Sangma and his family had forcefully occupied the household of late Kumudini C.H. Sangma and late Jinseng A. Sangma. Whether it was a case of forceful or forcible occupation, it is a different matter. May this be clarified that the appellant Srimati Pemilis D. Sangma, it is a matter of record that the respondent instituted the present suit only on 9/11/2015, counted from 1994, when LS disposition took place, onwards. It is thus clear that the respondent instituted the suit after a long period of 21 years only. In this contextual obtaining situation, the question then is, does procedural law allow such a very belated filing institution of the suit? The answer clearly is no. Here, legal explanation follows. It is a settled procedure that for recovery of immovable property, whether based on previous possession or on title, the suit for recovery has to be instituted, filed within 12 years from the date of disposition as prescribed under Schedule 1st Division Suits at serial number 64-65 of the Limitation Act. As already made clear, the respondent plaintiff filed a suit only after 21 years, and therefore her suit is not within the prescribed period of limitation. At this stage, one discussion on the Indian Limitation Act 1963 is inescapable. Within the legal fraternity, there are some who hold the opinion that provision of the Limitation Act are not applicable if and when parties to the suit are both members of scheduled tribe, such as in the instant case. Let me briefly dwell more on the subject. The state of Nagaland, like the state of Meghalaya in above tribal state, the case of Tenjenka and Ors versus Sri Tenjenka and Ors decided on 26/4/1991 in case number MA within bracket F number 29 of 1989. The Guwahati High Court ruled that the provision of Indian Limitation Act were applicable in the state of Nagaland, and also because Nagaland is a part of India, dealing with the same case of Temjanka and Ors versus Sri Temjanka and Ors on appeal against the Guwahati High Court decision. The Supreme Court reported in 2000.
That's all. Only on ground limitation 21 years.
Limitation.
And see the appellate order.
(69), Your Lordship. So, do I read the operative part or whole thing, Your Lordship?
Whatever you feel is helpful for your case.
Yes, Your Lordship. Page 69, Annexure 8, Your Lordship. Judgment in order.
It's a long judgment. No, where's the
Yes,
operative part?
Operative part is at page 20. It starts from, there is no, page 22, Your Lordship, I can read. And 26 is the operative order.
What page is it? 21, 22, 26?
You just said para number.
20?
Para number 22. These are the issues discussed by the judge.
Okay, yes.
It is page 22
Yes.
at page 74, Your Lordship.
Yes.
Yes. One of the issues, Your Lordship, issue number 2, Your Lordship. In the beginning, Your Lordship, number 2, whether landed or ancestral properties can be given to son as per Garo customary law and practice. So, paragraph number 22. With regard to issue number 2, there is no hard and fast rule with regard to giving of family.
Where he's dealt with the point on which the
2 is that paragraph
limitation point. That was what we're going to say. I'm not going to customary law.
Yes, limitation he has not discussed anything. He said no within the Garo's.
Where? Where's the issue?
It is page 26. Page 75, page number 75, paragraph 26.
Now, who framed issues?
issues this judge has issued.
Para 28, Lordship, that
No.
Judge framed.
There are no issues were framed by the village court, right?
No,
You can't expect that. Then in appeal also, it's just decided on the point of after 21 years
Limitation.
you've come to the court. You have been before village court, right? Now and then this judge frames issues.
Yes.
On the second appeal.
But before that, Your Lordship, I beg to
Para
submit.
28, even limitation is discussed, Lordship. The page 75 of this running page. Page 75, para 28.
But before that, Your Lordship, I beg to submit that, Your
Yes.
Lordship. Division bench of this Honorable Court, Your Lordship, has passed an order. I have attached with the affidavit, Your Lordship, additional affidavit, wherein it is that Your Lordship, this order was passed on 12th April 2017, that law of limitation is applicable within the state of Meghalaya, within the tribal
This is
region.
Maheshwari's judgment.
Yes, Your Lordship.
My lord was the party to.
Yes, my lord was the party.
I was not a party.
No, party no, one of the judge. One of the judge.
No. You see, I've just to be very fair. At that time, when the observations were asked, then I told the court that there are certain statutes here where it specifically provided, especially that limitation not apply. How will that be addressed? That was never addressed. Because in all, even 53 rules or the 37 rules, or even government rule, is specifically given certain sections that law limitation not apply. Now that's not addressed. That's the only thing. So whether a special provision will hold. Anyway, where's the judgment?
Judgment is in the affidavit filed by me on 3rd August 2022. Page
31st August.
12th. Yes, it was filed in. I filed the affidavit in 31st August 2022, and I have annexed the order at page 12, annexure B, Your Lordship, of this affidavit. Start from page 12.
No, to see where this point has been discussed.
It is a very lengthy judgment containing 24 pages. Page 13 also, it is a little discussion is there. Page 13, 14, 15 also, tribal areas it discussed.
Where is the operative part?
Operative part at page 29, Your
What
Lordship.
is judgment?
Page 29. Operative part of this affidavit.
So there's no paragraph given.
Last to page 29, Your Lordship. Page 29 of this judgment. Number 1 in second, third paragraph after 9. Point 9. Page number 29. Point number 9, Your Lordship.
Point number 9.
Point number 9. Page 29. Below that, in our view, aforesaid discussion of the Guwahati.
Waiting. Point number 9, what point number 9? Page 29.
Yes. Page 29, Your Lordship.
8, this audio is 30. Because of what has been discussed.
Yes.
1 second. Point number 9 is a quotation, not a judgment. It is not
Below that, Your Lordship, in our view, the discuss next paragraph. It starts from next paragraph. This page is the end of
Yes.
this. May I read, Your Lordship?
Yes.
In our view, the aforesaid decision of the Guwahati High Court aptly expound and clarifies the law to be applied to the question of limitation in relation to an application for review of an order passed in the proceedings under Article 226 of the Constitution of India, and we find no reason to take any defined view of the matter. Hence, while respectfully agreeing with the aforesaid decision of the Guwahati High Court in the case of Muririba, we are inclined to hold accordingly. MC Review Petition number 7 of 2015, Shala Action Committee versus State of Meghalaya and or conclusion in view of the above, the answer to the referred questions are as under. Number 1, the Limitation Act 1963 applies to the entire state of Meghalaya, including the tribal areas of autonomous district or region, Your Lordship.
See what happened. See, coming back to the history of this limitation was that in 1966 there was a notification issued by the governor. You remember that the limitation act not apply to to the tribal areas. But then that did not address the point with regard to special legislation where it's specifically given there that limitation not apply. There is still that grey area still remains. That's the thing. In spite of the full bench decision.
Yes,
so your only grounds is that 21 years or 21 years they have come.
Yes.
So what about the reason given? No. What about the that you say that it's not even explained? But she was a child then, correct? She was dispossessed. Correct?
Yes.
Then?
Not, but she was not adopted, Your Lordship. We came to know that she was.
We're not going to go appreciate that. The only ground that the village court decision set aside on the ground limitation.
Because village court has passed order ex parte, Your Lordship.
That doesn't matter. That doesn't matter, and the village, the subordinate council court did not address the case at all. They somehow sad to say this order was not written by the judge or presiding officer.
Yes. But Your Lordship.
It's very sad to say, but you have to make this observation in open court. It was not made. It has happened many times.
Thereafter,
once I read an order of the subordinate council court from Garos only. After reading it, I said it should be elevated straight to High Court.
So after 21 years,
because
she has come
with
Halpuri
was quoted, and all the doctrines, which were applicable. And after that, and when the matter was remanded back to that same court, next order that came was 4 lines. And that was set aside. So you see, that's the thing. That is one thing about certain.
But she was all alone.
See, this is not a question of reappreciating the facts. We're not reappreciating the evidence. It's just to see whether there is irregularity in their proceedings, whether the accurate jurisdiction,
yes,
or whether the finding. Now, even this this order of the subordinate is also not really sustained because it didn't address anything. Did it address the point?
She has not discussed anything, only the limitation part.
Did it address the point when ex parte?
No. Both
then?
They participated.
So what should we do? No, when ex parte against you said before the village court, correct?
Village court, yeah, because copy was not supplied. I received the summon, Your Lordship, but copy of the plaintiff was not supplied.
You never took part in the proceedings.
Yes, I went there, I verbally requested
now the thing is that now the village court, whatever it is, they vested with enough authority, they had given a finding on the Garo customary law, correct?
Garo customary law.
Yes.
So they are
and
saying.
And the fact that you that
she
was driven away.
Daughter-in-law.
Yes, whatever. Yes, and then the lineal descent cannot come from the men, right? So what do we do in matters like this? Now that order also, and then and he's gone on.
He's pleaded that he's a self-acquired property.
No. We're not going there. They have discussed that. We're not going to. We're looking into the veracity of these orders.
Yes.
Now this order says, discussing that Nagaland case and the Mizoram case on limitation.
I'll leave it to the discussion.
No, not leave it to the court. That is one thing which law should not do. You're supposed to assist the court.
Yes, Your Lord.
Then we dismiss it, we leave it to the court.
No, not
then.
Lord. But the only thing is that
we dismiss it. I mean, with 4 lines order also.
It is also discussed that a daughter-in-law cannot inherit the property of the in-laws. It is discussed also.
It's not that. It isn't that. You don't understand.
And it is
on the point of challenge, Then what he dismissed only upon limitation. That's all.
Yes. Without limitation.
Then in that
So if you want another round, we'll send it back to the
yes,
Sovereign
that
Council Court.
is fair enough.
That only serve the purpose because it's not examined correct perspective at all.
Yes. But not only that, Your Lordship, in that other case also.
He'll have objection.
Your Lordship, because as I said, Your Lordship, plain reading of the judgment by district judge of the District Council Court, he has discussed everything because my Lord has correctly pointed out because it is there because the main issue, which is raised and which is the main point, he has even discussed about Garu customary law. Page
yes,
4.
but then
and also
the trial court
ancestor property and that judicial sub judicial officer, she has discussed nothing only on the point of limitation. That also even in this judgment they have already clearly reflected and everything is at page 20. They have already discussed to that reply is given to that also. And here also in the absence of female issue.
If you want to discuss Garu customary law now the thing is that to the males, simply put,
yes,
whether it can devolve upon you. Can it devolve?
No.
Can property devolve on the male?
No.
It can only be maybe permissive possession given by your parents.
And
I might be wrong. I don't know about that.
Yes, it is in book.
In the book also they cannot.
Even after the death of the original owner, son has to return back the property to the clan member. It is in the book.
And it depends on the decision of those chras and chachis and maris and where it should go and whether if any property devolves, it devolves with the consent of the entire community there.
And here, Lordship, because they have clearly stated that family have no issue. So I was adopted since from 1987. And removed only from 1915 only they have 1914.
No, we're not going to the facts again, but you ran away or you chased away or
yes.
That is immaterial.
Yes, everything is what I'm trying to submit before this report is that everything is in detail. There is nothing, no illegality in the order passed by the judge of the District Council Court. That is what I'm saying. That's why, my Lord.
MS Bhattacharya, he's right. Because the only thing in your favor is the order of Sovereign Council Court, which is nowhere.
Not only that, Your Lordship, that patta is valid. Patta is after issuance of summon to the other party because I have not annexed, but I have the copies.
We're not talking about patta right now. We're talking about a substantive dispute that you have.
Because of this patta, I am contesting this petition, Your Lordship. Because I am the legal. Because patta already issued in my name.
Patta is not a title document,
Lordship.
Patta is never a title document.
I paid the rent revenue.
You can pay rent revenue. Patta is only a record of your possession. It's not a record. We call it in other parts in Assam. We call it Jamabandi.
Yes, yes.
So only things in your possession they come record and dark number so and so. Mr. A is in possession. That's all. It's not a document of title. You cannot claim your title on the basis of a patta.
Then in that even Your Lordship has to remand it back for fresh.
Lordship, we're not remanding it back for
Lordship.
fresh.
She has to establish and clearly show some illegalities in the order, which I should say the order passed by judge of the District Council. He has to show this is the wrong here because she has not found out even entire writ petition. It is just a history of the case. He has never challenged, he has never made an argument challenging the order and the lacuna or any loopholes in the order passed by the judge in District Council Court. And my Lord have correctly point out that now we cannot re-appreciate the evidence, what happened, who is how many year old, those things. It is already now only her part, petitioner. Duty is to establish that this order, there is some part in the illegality. She has to show that. That is what exactly my Lord was trying to
thank you so much.
No, she has to establish illegality in the order. Yes. Where is the order? Yes. Where is she? When in which para she has made an argument challenging this order, saying that this order is clearly wrong. Illegality.
The land devolved at Princess Sangma. He was given by her parents. You are the wife, correct?
Yes. Yeah. It was in his.
Then how will it go to daughter-in-law? That becomes more absurd.
Yes, she is the daughter-in-law, and she is admitting. Not even his son. Son already died.
Your Lordship may be remanded back for.
But I have a strong objection, Lordship.
No, we are not remanding it back.
Because Your Lordship, because ground I have objected, I filed rejoinder.
Okay, you prepare. I will go through it myself and see. We'll fix another date for this. Interesting.
Otherwise, Lordship, this has been keeping for long. Lordship,
No,
take
let
fast,
I
no?
just go to the rules on research also. Yes. The translated copies have been furnished and kept on record of the concern, proceedings of the village court. Stop. This is
Lordship,
has also been heard at
allowed to.
This is matter. You want to file an argument?
No. This translated copy will be available to us also. The copy.
Yes.
We can just read
copies
it.
of the same be also provided to the Lordship counsel for the parties. Stuff. I copy. This is matter also for further hearing.
And
interesting matter.
Maybe recorded as part hard matter, my
yes,
lord.
your lordship.
Which bench will it go to?
No, you will not go, but sometime my lord, she may take adjournment then.
No, I'll not take your lordship. I want to finish it. May I please, your lordship? Next item is similar matter, only WPC. Because against cancellation of patta. But there is some mistake in the order also, your lordship. Cancellation of patta.
That will look into it.
That one will on the next day.
32. Next date, your lordship.
That order. You know, now only one everything.
Much obliged.
Much obliged.
May please, your lordship.
Yes.
Your lordship, in this petition, I'm challenging the seniority, madam. Gradation list. Lordship has, last occasion, has heard this matter in length.
At length?
Yes, my lord. But just to refresh Lordship's memory, my entire case, my lord, hinges on a rule.
Hinges on?
On the rule, my lord, which they say that it is going against me, my lord. The rule is called the Meghalaya Directed Establishment Ministerial Service Rules of 2010. I've already placed it on record.
Yes. Give her your fan on kar do. Front में मौजूद रखो। थोड़ा यहाँ पे लेके थोड़ा सा बस और एंगल करो यहाँ से नहीं वो तो नहीं अब वो पंडित चली थे ठीक है बस Yes.
Lordship, just to refresh Lordship memory. Lordship, my case is that the petitioner was appointed in the year 2007, my lord. And the respond number 4, 5, 6 and 7, my lord, was appointed much later.
Appointed in? Okay.
So annexure number 1, my lord.
Okay, yes. So just a year. Yes.
And but there was a clerical error in the first appointment, my lord. So she was appointed annexure number 4, page 20. 1st June 2007, my lord.
Yes.
Thereafter, gradation list was published, my lord. That will be in annexure number 6, page 23.
Regular appointment.
My lord. The relevant portion will be at page 24, my lord.
Yes.
Here the respondent number 4, my lord.
Is respondent 4 is presented here? Apart respondents here?
All the respondents, my lord, just to bring to notice of this honorable court, my lord, this respondent number 4, we are having no grievance against respondent number 4 since he has already taken voluntary retirement, my lord. During the pendency of the matter.
Number 4.
Watch it.
R4 is
Sri G.S. Lingam.
G.S. Lingwa.
Watch it.
Okay, 5, 6 and 7 were completed subsequently. You are appearing for all of them? Yes. Okay. Yes.
Here, page 24, my lord, Lordship will find respondent number 4 at page 22. whereas respond number of petitioner at serial number 30, Malord.
Yes.
And respond number 5, 6, and 7, what you will see at serial number 32, 33, and 34.
Okay.
Here the petitioner is above the private respond number 5, 6, and 7.
Yes. Yes.
Thereafter, being aggrieved by this gradation list, a representation was submitted. That will be annexure number 7, page 28. Page 26. Thereafter, another gradation list was republished.
1 second.
Gotcha.
On what ground you made a representation?
On the ground of rule, my lord, that the rule is in our favor, and as per the rule.
Okay.
Yes, that will be from the date of appointment. Then thereafter, another gradation list was republished, my lord. That will be annexure number 8, page 28. The relevant portion would be at page 29.
Yes.
Here the petitioner's name is shown at serial number 28. Above private respondent number 4, 5, 6,
5,
and
6,
7.
and 7.
Yes. Their name would be found at page serial number 31, 32, 33, 34. This is the correct position.
Yes.
Then thereafter, my lord, another gradation list was published. That would be at annexure 9, page 31. The relevant portion would be page 32, my lord.
Yes.
Here the petitioner's name is shown at serial number 23, my lord.
Okay.
And the private respondents are at serial number 26, 27, 28, and 29.
Yes.
Thereafter, my lord, another gradation list was published in the year 2014, annexure 10, page 38.
How many gradation lists are here?
So that would be 5 copy, my lord.
Annexure?
This is the annexure 10, my lord. The
Annexure 9.
Annexure
10. Okay.
10,
So
my
I'll show
lord.
you.
Page 38.
Page 35.
38, my lord.
38. Oh.
Lordship. That is the annexure, that is the type copy, my lord.
Okay.
The relevant portion will be page 39. Here again, my lord, they have changed they have placed the private respondents above the petitioner.
Yes, okay.
Serial 23, 24, 25, 26, and the petitioner will find page, serial number 27.
Serial number 23, 24, 25.
25, 26, private respondent. The petitioner is at serial number 27.
Yes.
Being aggrieved by this gradation list, a representation was filed, annexure 11, page 41.
Okay.
They have furnished a reply, annexure 12, page 43. Lordship will allow me to read the last paragraph.
Yes.
Under clause B of subrule 1 of clause D of subrule 4 of rule 49, this should have been 29, my lord.
Okay.
of the Service Rule of 2010, the inter-seniority shall be in order names appear in the merit list of the MPC, and further in between LDAs shall be according to the dates of appointment. They themselves have admitted, my lord, that seniority shall be as per the date of appointment. The date of appointments of promotees from types were issued, but indirectly they have rejected my representation.
Date of appointment of promotee typists issued prior to appointment of seniors. Yes.
But as per the rule also, my lord, even if the typists were appointed on the same date with the LDAs, my lord, on the competitive examination, then also the typists will be made junior. As per the rule, my lord. Thereafter, another gradation list was published in 2017, my lord, annexure 13, page 44. The relevant portion will be at page 45. Here the respondents...
The final gradation list?
No, my lord. The final gradation list is at page...
okay.
2017. If Lordship wants to come to the final gradation list, my lord.
No, so again, still showing. Okay, fine.
Here again, the private respondents were placed above the petitioner.
Yes.
Thereafter, representation was filed, my lord, annexure
14.
No, page 14 is their justification, my lord, as to why the private respondents were placed above the petitioner. The Lordship may allow me to read the relevant portion.
Yes.
Para 2. Hence, the draft gradation list order number so and so was finally determined according to the merit list from MPSC as provided under Rule 29 1B and 29 4D, read with OM PR 2009, dated 25/11/2009. Lordship, on last occasion, I've made my statement, my lord, that this particular OM, my lord, has been set aside by the division bench, my lord. So,
which OM is
this? The red with OM number PER AR 68 2009.
When was it set aside?
I think I've already placed a judgment also, my lord.
When?
I'll just 2022, my lord. 9/11/2022.
So at the relevant point of time is still in force. This letter is 2020.
Lordship. No, but as of now, that is what I'm saying, my lord.
Yes. (2022)
Lordship.
Okay.
In WPC number 394 of 2021.
Yes.
Thereafter, representation was again submitted, my lord, annexure 16, page 48.
15 or 16?
No, annexure, page 48, my lord, annexure 15.
Yes. Yes.
Thereafter, another gradation list was published in their page 50, annexure 16, my lord.
My God, this is a surplus of these gradation lists. Page 50.
16, my lord.
16.
Page 50, my lord.
So what is the period now? This is 21. So since 17 even superseded, correct?
Lordship. But we have been
You didn't come to court in 17 straight away.
No, we are seeking a remedy before the department, my lord. We're filing the presentation.
Because otherwise, we shouldn't come to a case where we try to unsettle a settled position. That's the only thing. If they've got, Maybe have they got promotions subsequently to, are they still the same post?
They're in the same post now. They have not been promoted as of now.
Okay.
But what has happened, my lord, during the pendency of this matter, they have come up with another gradation list, my lord. I filed it by way of misapplication.
This is 2021 is another gradation list.
Lordship. Then meanwhile, when the matter was still pending before this honorable court, my lord, for adjudication.
It's confused. Now this is which this is you're placed in year 21.
Lordship. The relevant portion will be at page 54, my lord.
54.
Lordship. Here the private respondents were placed above me at serial number 17, 18, 19 and 20.
Okay.
The petitioner is at serial number 21.
Yes.
I beg to submit, my lord, during the pendency of the matter, they have come out with a new gradation list, my lord, which I have placed it on record by misapplication.
One misapplication. Why is this case not taken up again? We were supposed to take instructions on this.
Lordship, they have filed their affidavit in opposition to the effect also.
To the miss case.
Lordship.
Okay. Now, where were you placed in this last miss case, in that relation list? This is dated February 23.
Lordship.
Where are you?
Just a minute, my lord.
Where are you? Page 14. Twenty.
What?
You're at 20. And where are the private respondents?
Page 20. Private respondents at 17, 18, 19. My lord. By this time, my lord, the private respondent number 4 has already taken voluntary retirement.
Yes.
So, my lord, I'm before this honorable court, my lord, as the entire case, my lord, depends on the rule, my lord. If the rule is in my favor, my lord, I'll be successful. If not, then
yes.
If lordship can come to the rule.
One thing, Mr. Momin, is that
lordship,
you came to court on which this is 21.
21.
Now, since 2014, firstly you were on top, but after 14 you were consistently shown below the private respondent, correct?
Lordship. We have been agitating a grievance.
Of course, on that we're not saying that you haven't agitated, but after 14 you've been shown consistently below a private respondent.
Lordship.
Okay. Now, how do you say the rules will help you?
The rules, my lord, clearly says, my lord.
Yes.
Kindly come to page 11 of the rule.
1 second. Where are the rules? Here's the rules, correct?
Lordship.
Now you interpret the rules.
Lordship.
As to how you, the entitlement, why were you superseded
Lordship.
since 2013? Yes.
Lordship comes to page 11.
Yes.
Clause D. Page 11.
Yes.
Sub 4 clause D, my lord. If I may be permitted to read.
Read.
The inter se seniority of the lower division assistant appointed under sub rule 1, 2 and 3 of rule 9 shall be in order which the names appear in their list respectively. The inter se seniority in between lower division assistants required under any of the aforesaid sub rules shall be according to the dates of appointment, my lord. My dates of appointment is prior to dates of the private respond number 5, 6 and 7, my lord.
No, one thing is whether the appointment is from the same route, or is it from different?
No, from the same room, my lord.
They all be appointed similarly.
Lordship. So far as private respond number 5, 6 and 7 is concerned, my lord. But so far as respond number 4 is concerned, she was promoted, my lord. But I have no grievance against respond number 4 as of now because she has already.
No, whatever it is. So you were a direct recruit also.
I'm direct.
Correct. So the other 5, 6, 7 are direct recruits also.
Lordship.
Or did they come from a different feeder class?
No, they are from direct recruits, my lord.
Okay. So you say that you only you hinge and saying it is a seniority shall be according to the dates of appointment. That's it.
Yes, my lord. But now, in their reply, my lord, they have.
No, just continue with your case.
No, in their reply, they have been harping on rule 29. So far as private respondent 5, 6, and 7 is concerned, my lord, they are harping on rule 29, 1B, my lord. That will be page 10, my lord. If I may permit to read, my lord. The inter se seniority of the lower.
Okay. Comes back to the MPSC results.
Lordship. The inter se seniority of the lower division assistant mentioned in clause B of sub rule 1 of rule 3 shall be in order in which the names appear in the result of the competitive examination conducted by the commission. Such lower division assistant shall be junior to the lower division assistants falling under clause A.
You're reading D?
B, my lord.
B or D?
B, my lord.
29 1B.
29 1B, my lord, page 10.
Yes.
They say that this particular provision is going in their favor, my lord.
What is inert?
Hello?
I mean, what do you mean entire? Okay.
It should be inter se, my lord. So, if lordship comes to clause C.
1 second. Yes.
If lordship comes to clause C. The inter se seniority of the lower division assistant mentioned in clause C of sub rule 1 of rule 3 shall be in order which the names are arranged by the government for the purpose of appointment. The inter se seniority of the assistants appointed under clause B and C of sub rule 1 of rule 3 shall be according to the dates of appointment. This is my case. I'm saying that my date of appointment is prior to private respond number 5, 6 and 7.
Where's rule 3? What does it say?
Rule 3 is at page 2, my lord.
Yes.
Constitution, the service shall consist of the following persons, namely. Page 2, my lord. A. Members of the Assam Directorate Establishment Ministerial Service Rules to the State of Meghalaya in accordance with the provision of Section 64(1) of the Northeastern Reorganization Act of 1917. We are not concerned about this, my lord. We are only concerned about B. Persons recruited as lower division assistants and typists in the offices of the heads of department mentioned in column 1 of Schedule 1 on the result of the competitive examination conducted by the Commission. So we're only concerned about this, my lord. Will be
with 3B.
3B, my lord. Because they are lower division assistants.
Yes.
So my interpretation is, my lord, that because my date of appointment is prior to the date of appointment of the private respond number
Was it by application reservation policy? That's why you appointed before.
Yes, my lord.
Okay.
There is
And
the
that
reason-
seniority we sought to restore it by going to results of competitive examination.
Lordship. No, but if Lordship reads this clause C, it's clear, my lord, that the date of appointment will be considered for seniority.
Clause C 29.
Lordship. 1C of 29. 29 subclause, subrule 1 of clause C. So my entire case.
Your case is it's so 29 1B. You mean C 1C? Sorry.
1C, my lord. Yes. Just to reiterate my stand, my lord, I'm relying on the judgment, Supreme Court of 2018, my lord. Sunaina Sharma and others versus State of Jammu and Kashmir and others. The relevant portion is at para 11, my lord.
Yes.
At this stage, it would be pertinent to mention that it is a settled principle of law that normally no person can be promoted with retrospective effect from the date when he was not born in the Kedar. Seniority has to be reckoned only from the date the person entered into that service. In this behalf, reference may be made to the judgment of this court in State of Bihar versus Akuri Sachindra Nath, where this court held as follows. It is well settled that no person can be promoted with retrospective effect from a date when he was not born in the Kedar, so as to adversely affect others. It is well settled by several decisions of this court that amongst members of the same grade, seniority is reckoned from the date of the initial entry into the service. And also, para 12 also in my favor, my lord, it says that instead of Uttaranchal versus Dinesh Kumar Sharma, this court held as follows. Another issue that deserves consideration is whether the year in which the vacancy accrues can have any relevancy for the purpose of determining the seniority, irrespective of the fact when the persons are recruited. Here, the respondent's contention is that since the vacancy arose in 1995-96, he should be given promotion and seniority from that year and not from 1999 when his actual appointment letter was issued by the appellant. This cannot be allowed as no retrospective effect can be given to the order of appointment order under rules, nor in such contention reasonable to normal parlance. This was the view taken by this court in Jagdish C.H. Patnaik versus State of Orissa. This principle is followed in S.K. Abdul Rashid versus State of Jammu and Kashmir, again dealing with the J&K civil service rules, again in State of UP and Ashok Kumar Srivastava. This court held that the normal rule is that seniority should be reckoned from the actual date of appointment. It was held thus, in view of the aforesaid enunciation of law, the irresistible conclusion is that the claim of the first respondent for conferment of respondent or retrospective seniority is absolutely untenable, and the High Court has fallen into error by granting him the said benefit, and accordingly the impugned order deserves to be lancinated, and we do so. And another would be at para 17, Manu, the relevant portion. In Suraj Prakash Gupta case, this court held that direct recruits could not claim seniority from the date anterior to their appointment. The reason is simple: the direct recruits were not even born in the Kedar and were not holding any post in the service. There can be no manner of doubt the direct recruits cannot be seniority from the date prior to their appointment.
Okay, that's it.
That's it, madam.
May it please your lordship.
Yes.
Your lordship, I'll just go first to the rule 331B.
31B. Yes.
Your lordship, there is no disagreement by the petitioner that this is the source section from which the rights are flowing. So, person recruited on LDA and typist in the office of head of department mentioning so and so on the results of competition exams.
Yes.
So Lordship, the results of competition exam is the starting point.
Yes.
And now, Lordship, we come to, since respondent number 4 is out, so we will not go to 9. We'll just come to 29, Your Lordship. 29 1B.
29 1.
1B. 1B.
1B.
Lordship. So 29 1B is basically it expands the meaning of 31B. The inter se seniority of LDA mentioned in so and so shall be in order. I'll go slow, Your Lordship. In order in which their name appear in result of the competition exams conducted by the Commission.
Yes.
So, Lordship, the order in which the name appears is very, very crucial.
Okay.
So, 29 1C will not be applicable. That will be only, Lordship, that this section will be only applicable if 1B is exhausted. 1B is exhausted and there is no challenge to 1B and the date of appointment is same. So, Sir Lordship, first we have to overcome 1B. Now I straight come to my affidavit, Your Lordship. Affidavit filed on 29/9/2021. Page 25, Your Lordship.
29 9. 23 9.
23 9, apology, Your Lordship. You just come to page 20, annexure 2, page 25.
Annexure 25, page 25.
Page 25, Lordship. Annexure 2. Lordship, allow me to read. Madam, I finally determine inter se seniority of employees in the Directorate of Commerce Industries and have been circulated amongst employees of Directorate by applying Rule 29 1B. 1C is not in the 1C is not been invoked. 1B and 29 4D of so and so. Now, Lordship, these two rules have been invoked. Now we come to serial number 20, Lordship. GS Lingua, my friend petitioner is not, because this is a case of promotion, Your Lordship. So we are only into their name in order of the way the name appeared. So if you come to the next, Your Lordship, 21, 22, 23, 24, 25. 25 is the writ petitioner, Your Lordship.
Yes.
Now, sorry, 24. Let me come to 21, Your Lordship. This is the list which we have quoted.
20?
21,
Yes.
22, 23, and 25, Your Lordship. Let me come to 21 first, Your Lordship. Ranked 53 in the merit list. 22 ranked 55. So the important word is ranked, Your Lordship. This is in order of merit, 29 1B. First is on 53, second is in 55. These are private respondents. Third is in 58. Petitioner is 68.
No, okay.
And then FX Sama is 82. So Lordship, petitioner is at
24.
24 is at 68.
Yes.
In the select list prepared by MPSC, complying with the rule 29 1B, in order of merit, Your Lordship, petitioner is at 68.
She was appointed when? 1/6.
1/6.
He's a 4/9, 5/9.
Lordship, if I may just pause for a minute, as I said, we have to first overcome 29 1B, and we have not invoked 29 1C. So, in order of list, in order of merit, so there is no question of interpretation of rule, Your Lordship. In order of merit, she was at 68. And so this Lordship raised a very important query. What was this happening for so long? This was exactly the problem that was happening, Your Lordship. Draft list was prepared.
So first time she was given as per date of appointment.
Lordship, yes. It should have been as per from the date of list prepared, and that the parameter of that comes within the meaning of 29 1B. So Lordship, if you see this particular date list of merit with 29 1, I don't think so the writ petitioner has got any merit, any case, Lordship.
Continue.
So far So Lordship, so for 21.
So you mean that it's squarely covered by
Absolutely, Lordship.
by 29(1)(b?
Lordship, if I may,
that the rules provide that as per the ranking. In
Lordship, if I may just read again, shall be in order in which the name appear in the results of competition exams. Detail, the rules have been very specific, Your Lordship, and the details in which the name appears is very, very obvious, Your Lordship.
Suppose that a person is appointed 1 year after, before the expiry of the select list, even then.
Lordship, that would be in a different situation. Lordship is correct. Select list has to be, at least life has to be expanded.
Oh, how do you find they all within a few months?
Within a few months,
yes. 3 months.
But Your Lordship, it comes squarely covers between 29(1)(b).
Okay.
If it did not cover between 21(1)(b), then Lordship then we may have to venture 29(1)(c). But we have not even invoked. Lordship will scarcely see. That's why I read out the first page. We have only squarely invoked 29(1)(b).
Yes.
And 29(4)(d). And Lordship, 29(4)(d) is Lordship, if I may just come to 29(4)(d). First, it is squarely covered under 29(1)(b), and second, Your Lordship, the interstice seniority of LDA assistants appointed under sub-rule so and so 9(1)(2)(3) shall be in order in again, Your Lordship, shall be in order in which their name appear in the list.
Where reading? 29?
29(4)(d), Your Lordship.
Yes.
Interstice seniority of, I'll come to 9(1)(2)(3), Your Lordship. The interstice seniority of lower division of assistant appointee under sub-rule so and so shall be in order in which the names appear in the list respectively. The interstice.
How do you distinguish this? How outside has given the appointment? How do you distinguish this one?
Lordship, first the list has to be exhausted. And the exhaustion of list will happen only Lordship, we can imagine a situation in the merit list prepared. If his name was on top, and then we would have, if the state would have appointed somebody from below, in spite of the fact the name is, in supposing this in the merit list, in the MPSC list, name was at number 4, and somebody from number 7 has been appointed, and then there is a question of interpretation. Lordship would then just go squarely go to the MPSC merit list. Now 29(1)(b) gives the power for 3(1)(b), Lordship, which they are not denying it. We have expanded that. And then 29(4)(d) clearly says from the list, and it says LDA assistant 1, 2 and 3. 9, now Lordship, 9, 1, 2 and 3. Lordship, allow me to just go to 9. But whether they are part of the same cadre. Lordship has said that's important because respond number 4, Lordship, is a promotee, and they're not pressing for respond number 4, GS Lingua. They're only pressing for the.
Yes.
Another aspect, Lordship, is it's from the same list and they are all direct recruits. Same direct recruits from the same results, from the same MPSC list. Lordship, if I just take to page 4.9.
The 9(1).
9(1), Lordship. Lower division club appointment to the post of LD assistant shall be made by direct recruitment on the results of competition exams conducted by commission. Lordship, it's everybody's case that this is a case of a direct recruitment. It is not a case of 9(2), Lordship. 9(2) was only respond number 4. Okay. So we exclude that. So Lordship, 29(4)(d).
Yes.
29(1)(b) talks about competition exams under Rule 3.1. 29(4)(d) again talks about 29(4)(d), Lordship, again talks about direct recruit under 9(1)(2)(3) and promotion. And we have quoted both 29(1)(b) and 29(4)(d). Even if we invoke 29(4)(d), the name shall be in order in which it appears in the list respectively. So again, Lordship, if I come back to the same annexure, page 25, annexure 2.
So why do you say 9(1)(2) and 3 is not applicable at all?
It is applicable. It is applicable, Lordship. Only 9(1) is applicable.
Yes, that's only 9(1). 2 and 3 is no application.
2, Lordship, 2 would have been applicable for respond number 4. So only we are concerned with 9(1).
Now the 3 is by section grade 4 staff.
So we are concerned with 9(1). Purpose of quoting 9(1) specifically, Lordship, it's a direct recruitment on the results of competition exams.
Yes.
So they come within the category of direct recruit. They also come within the category of competition exams. They come within the category of same list, and from the same list, I've read out, Your Lordship, page 25, the order in merit. So if that is the case, Your Lordship, it's apparent.
The date of appointment has no consequence.
Absolutely correct, Your Lordship. 29(1)(1)(b) will stop at that, and date of appointment has got no relevance. The application of that rule is not relevant here. And my learned friend relied on the judgment, Your Lordship, totally out of context, has nothing to do with the rule. It's in a different scenario. Your Lordship, this is my summation. There is no merit in the writ petition.
Yes, Mr. Jindal.
May it please your Lordship. Lordship, very short responses from my side. First response, my Lord, is a request for my Lord to kindly look at the original writ petition, specifically page 14 thereof.
1 second. Page 14.
14, my Lord. That is the prayer portion, my Lord.
You have not incorporated the new relation list, you mean?
No, my Lord, I'm on another point.
Yes.
If I'm allowed to read the prayer, my Lord, it's in two parts. First part is, in the premises aforesaid, it is most respectfully prayed that your Lordship would be graciously pleased to issue rule, call for the records, and after hearing the parties, be pleased to set aside and quash the order dated so-and-so, so-and-so, so-and-so. Next part, and further be pleased to direct the respondent number 1, 2, and 3 to place the petitioner ahead of the respondent number 4 in the gradation list. Why I am highlighting this is for the reason that the writ petition that was filed originally was directed squarely and solely against respondent number 4. In respect of respondent number 5, 6, and 7, at that time, what was the approach of the petitioner? That is at page 48.
One second. Page
48.
Okay, 48.
48, my Lord, is a letter dated 9th November 2020 from petitioner to the Director of Commerce and Industries. I will skip most of it. Page 49, my Lord.
Yes.
Page 49, the last paragraph, just the first line is relevant. Last paragraph. On perusal, my Lord. On perusal of the rules quoted herein above, it is clear that serial numbers 21, 22, and 23, that is respondent 5, 6, 7, is made senior to me as they fall under Rule 29(1)(b), which I am not pressing upon as their name appears to be above me in the merit list conducted by the MPSC. So, when writ petition was filed, petitioner was very clear that 5, 6, and 7, I have no grievance, they are above me, rightly they are above me, through operation of 29(1)(b).
Yes.
Now, during the pendency of the writ petition, respondent number 4, against whom the writ was directed, retired. So the cause of action as such disappeared immediately.
Yes.
I would submit from the date of retirement of the respondent number 4, this matter has become infructuous. Now, to keep this infructuous matter alive through some means, now from respondent number 4, the guns have been trained now on 5, 6, and 7. At the time when writ was filed, petitioner was clear, 29(1)(b) rightly operates to grant seniority to 5, 6, and 7. Now, to keep this matter alive, she is disowning 29(1)(b) and focusing on 29(1)(c) and 29(d). I'll come to that also. So this is my first point, that through admission of the petitioner herself, there is no more cause of action for the writ petition to stand or for this miscase to stand. That's first, number 1. Number 2, without taking up too much time on other unnecessary aspects, going straight to the rules themselves, my Lord. The state, my Lord, through Learned Senior, has well explained the rules, but with respect, I beg to differ with one interpretation that was advanced. Now, to appreciate Rule 29, Lordship will have to look at the rules in entirety, starting with Rule 3. Now, Rule 3, Lordship would have observed, it says the service shall consist of the following persons. A, members of the Assam Directorate so-and-so, first category of persons who shall be part of the service. B, persons recruited as LDAs, etc., on the result of the competitive exam. So second category where all concerned are located, are to be found, is the persons who are recruited through competitive exams. Third category, not relevant, retrenched personnel of so-and-so department. So there are three categories of persons who constitute the service as per Rule 3. We are concerned with the second category, persons who are recruited through competitive exams. Now for this second category, there is Rule 9, which Lordship has already seen.
Yes.
Rule 9, appointment to the post of LD assistants shall be made
9.1
by direct recruitment on the result of the competitive exam conducted by the Commission. So it is very clear there are three categories. All of us today, before this Honorable Court today, are from the second category, and we were to be recruited through competitive exam, which was the case. Now, having been recruited through competitive exam, what would be the seniority between these LDAs? That is, Lordship has seen at 29(1)(b).
Yes.
The inter se seniority of the 29(1)(b), my lord, inter se seniority of the lower division assistants mentioned in clause B of sub-rule 1 of Rule 3, that is my category, shall be in the order in which their names appear in the result of the competitive exam conducted by the Commission. Senior has already placed that list, which shows very clearly that 5, 6 and 7 were above petitioner in that competitive exam, my lord. The matter should end there. However, as I've just pointed out, in an effort to keep this matter alive, petitioner is now relying on clause 4D and 1C. I'll just look at 4D first, my lord.
4D?
29 4D.
Yes.
Next page, page 11, my lord. I'll read this, and I'll read this slowly, my lord. The inter se seniority of the lower division assistant appointed under sub-rule 1, 2 and 3 of Rule 9 shall be in the order in which their names appear in the list respectively. The inter se seniority in between lower division assistants required under any of the aforesaid sub-rules shall be according to the dates of appointment. Petitioner has picked up the word appointment, has hung on to it, and is trying to impress upon this Honorable Court that the defining or the fulcrum on which Lordship decision should rest is the date of appointment. That is not so. If I'm allowed to read the second line again, the inter se seniority in between lower division assistants required under any of the aforesaid sub-rules shall be according to the dates of appointment. How is this to be reconciled? This is to be reconciled by appreciating and understanding that this speaks of inter se seniority between the three categories.
Okay.
Not category B only. For category B, first line is there, in which the names appear in the list. But when it is a question of inter se seniority between A category, B category, C category of Rule 3, then it will be according to the dates of appointment. Naturally, because there was no competitive exam for category B and C. So it has to be date of appointment, but date of appointment only when there is a question of seniority between these three categories. But if it is a question of seniority within the category,
yes,
then it is the seniority will depend on
so
the.
it means that the 3.1 is that is not limited to like 3.1b. That's what it means.
Yes, ma'am.
Because 3.1b says like the other concern of a competitive exam. That's it.
Yes, ma'am. So there are three. So the reason why right at the beginning I highlighted the fact that there are three categories is because this rule, this provision, is to operate when there is a question of who is senior between the three categories. Then date of appointment comes into play. Similarly, my lord, 29(1)(c) also attempted to be relied on by the petitioner. I'll read, my lord. The inter se seniority of the lower division assistants mentioned in clause C of sub-rule 1 of rule 3 shall be in the order in which their names are arranged by the government for the purpose of appointment. The inter se seniority of the assistants appointed under clauses B and C of sub-rule 1 of rule 3 shall be according to the dates of appointment. So again, when there is a question of seniority between category B and category C, then the defining factor has to be date of appointment. The relevant factor has to be date of appointment.
That's it.
I would assume so. So my points are limited. 2 points. One, petitioner through her own admission has been very clear. She has no grudge, no axe to grind against 5, 6, and 7. At one point, she had conceded that the operative rule is 29(1)(b). And second point is, even leaving the first point aside, second point is a slow reading of the rules will show that the case of the petitioner at the moment through this missed case is actually no case with respect. Lastly, my lord, the judgments. 2 judgments were relied on. Supreme Court judgments. Lordship, as my senior had pointed out, they operate in a different field, my lord. 2018 judgment, Sunena Sharma, it addresses the issue of retrospective promotion or seniority. We are not on, there is no issue of retrospective promotion seniority in our case, my lord. Similarly, the second judgment also, I would only say that there is no relevance of that judgment.
That's it. Any reply, Mr. Moment?
Yes.
Lordship, the matter has gone ex parte against me. That is one thing I should have highlighted right at the beginning.
It's gone ex parte against you?
On 19th April.
That I was about to highlight.
Then you didn't file for ex parte?
No, because I humbly submit I'm not required to, in view of the law on this point, my lord. If Lordship allows, I'll place that law. Even though it's gone ex parte against me.
Let's see that. That's interesting.
Lordship,
you went ex parte on?
19/4/2022. Yes, ma'am. It went ex parte for the obvious reason that there was no case against me, no grievance or no relief sought.
I will bring it if my seniors over with the submission.
Lordship, the full bench of the Supreme Court at para 29 of this judgment through this judgment, my lord, in this judgment, they have discussed Order 9, Rule 7, when matters go ex parte, etc. 29 and 30, my lord, I'll read. Now, Rule 2 only applies when one or both of the parties do not appear on the day fixed for the adjourned hearing. In that event, the court is thrown back to Order 9 with the additional power to make such order as it thinks fit. When it goes back to Order 9, it finds that it is again empowered to proceed ex parte on the adjourned hearing in the same way as it did or could have done if one or other of the parties had not appeared at the first hearing. That is to say, the right to proceed ex parte is a right which accrues from day to day, because at each adjourned hearing, the court is thrown back to Order 9, Rule 6. It is not a mortgaging of the future, but only applies to the particular hearing at which a party was afforded the chance to appear and did not avail himself of it. Therefore, if a party does appear on the day to which the hearing of the suit is adjourned, he cannot be stopped from participating in the proceedings simply because he did not appear on the first or some other hearing. Next para, my lord, makes it clearer. Number 30, but though he has the right to appear at an adjourned hearing, he has no right to set back the hands of the clock. Order 9, Rule 7 makes that clear. Therefore, unless he can show good cause, he must accept all that has gone before and be content to proceed from the state at which he comes in. But what exactly does that import to determine that, etc. So, my lord, it's very clear from the full bench of the Supreme Court that, in fact, at some point in this judgment, Supreme Court has clarified there is no such thing as such as ex parte. If you do not appear, you have to suffer the consequences. You can appear on the next date, and
we have reservations about that anyway.
Lordship, we have to bow down to this point. So I'm allowed to participate. I'm participating now because I've been made a party in this miscase specifically, even though there is an ex parte order, and naturally the outcome of this miscase affects me directly. So I am content to accept whatever has happened before in this case, but today I have appeared and I can participate further as per this judgment, my lord. Acknowledged.
Just to rebut what my learned seniors has stated before this honorable court, my lord, I would like to highlight this is affidavit in opposition filed by the state respondent, my lord. This will show why I had to make private respondent 5, 6, and 7 as a party, my lord.
Where is that?
Para 11. Affidavit in opposition filed by the state respondent on 22nd September 2021.
Now, once you see, Mr. Moment, once rules are in place, and then there's very little room for maneuvering. Another thing that goes against you is that you step over your rights for a long time. That's the only thing. Anyway,
Lordship.
Yes. Where?
Para 11, my lord.
Para 11.
Lordship. Page 7 of their affidavit in opposition.
Page
7.
Yes.
Page
7 is para 10.
So this is affidavit in opposition filed on 22nd September 2021.
Para 11.
Para 11, my lord.
Okay, yeah, page 8 here.
Yeah, para 11, my lord. Second para, my lord. However, lordship.
Yeah.
If I may be permitted to read, my lord. However, as it appears, the petitioner ranked 68 in the merit list, and as such, the petitioner's rank has been taken into consideration while preparing the gradation list as per the relevant clause of Rule 29 of the rules. Had there been no other employees in between them, the petitioner would have been senior to the respondent number 4, applying clause D of sub rule 4 of Rule 29. They have conceded, my lord, so far as respondent number 4 is concerned.
No, but this answer to the respondent number 4 is an answer to the other respondents.
Lordship, that is the reason why we had to make them a party, my lord. If we were successful against respondent number 4, we were successful against respondent number 5, 6, and 7.
He came from a different feeder cadre.
Lordship, but date of appointment was considered.
So date of appointment will be considered then, because then you have to, if you apply that 29.4 whatever, then you have to take it because the NTC is between two groups. It's not between.
Lordship,
like your case confined to people similarly situated.
Lordship,
come to exam. So the case becomes very black and white in the sense that if the apply the rules in toto, that means that. As by your own admission, that letter, I have no grievance because we have come to exam, and the rule provides that that is the thing. So what remains?
No, the reason why I'm pointing this out, my lord, was that because of this affidavit in opposition, we made them a party, my lord. Private respondent number 5, 6, and 7.
But it becomes inconsequential.
But Rule 29 actually, my lord.
Even then, you split. Even if you splice that rule, so it will not help you.
Because Rule 29,
that you all come from, if you come from the same stable.
Lordship.
Yeah. So like if a company, suppose you have 3 stables and different type of horses, if you consider them in the race is different. But
Lordship.
then if you come from same stable, like the grading will be as per
Supreme
the
Court
one
also
stable.
is clear, my lord. So far, Supreme Court is clear that the date of appointment should be considered even for seniority, my lord.
But see, if these rules which govern you specific to you.
Lordship.
Yeah,
no.
right?
That is what they are interpreting. My interpretation is different again, my lord. So
how will you say Supreme Court? That refers to another situation altogether. It regards respect
but Rule 29B,
when you're born in the cadre.
Rule 29B can be invoked only once they are appointed on the same date, my lord. It cannot be invoked later, much later, even after like 6 months, 7 months, they are appointed later, my lord. Even they are coming up from the competitive examination. They cannot steal over a march, my lord.
You show an authority then. That on different dates of appointment, like even if it provides that that by the ranking should be seniority considered by your results that come to the exam, show a ruling that says that irrespective of the ranking which the rules provide, their appointment will be the defining factor.
The one which I have submitted, my lord, that also talks about seniority, my lord.
This is regard about promotion, see.
No, it regards about promotion as well as seniority, my lord. It talks about seniority as well. Can you come to para 17, my lord? Talks about seniority, my lord.
I don't think this will help you.
They were not even born in the Kedar, my lord, at that point of time. So how can it be made senior to the petitioner?
No, because the rules, they are creating a bar for you, no?
No, that rule 29...
See, the rules create a bar for you.
Lordship.
The rules have created a bar.
But in fact, the rule is in my favor. That's what I'm saying, my lord. The rule is in my favor.
See,
that is
then
the
why you admitted that you have no grievance against them then?
Earlier point of time, we were not aware about this rule, my lord. About rules, clause C, my lord. We thought that we were concerned only about rule 29B, but once this entire rule is read in toto, my lord, then only we came to know that we are made senior to them, my lord. We should be made senior. That is the reason why we have filed this.
I think there's some other matters there, but around the same, some excise matter.
Because lordship, if lordship reads rule
that which goes against you, decided by this court itself. Same as reverse.
Lordship.
These people were appointed before, but in the merit list he was inserted only because at that point in the quota there was no place for him. So from same status when he was appointed, then seniority was challenged, but there is a judgment. I don't know, Mr. Khan might be aware. I've forgotten the name of the case also.
But my interpretation of this rule is that, my lord, if rule B is invoked, clause B is invoked, my lord, then their date of appointment should be same. Then only the ranking will come in picture, my lord. But here the date of appointment is different. They are appointed much later. What prohibited the state government from appointing the respondents, private respondents on the same date, my lord, if they were senior? Then that means there was no vacancy at that point of time, my lord.
So if your argument is on the point that their seniority can only be calibrated from the time you were born in the cadre.
Lordship, that is
so
what I'm
can be given like anti-seniority before you were
no, that is why I have submitted that, relied on that judgment, my lord.
Yes. You answered that point, Mr. Khan. Yes. It's valid.
Lordship.
But if you stick to the rules, then again the rules are...
Lordship, that was the reason I imposed a self-restraint, what my friend expanded the argument. I didn't go into that. Because that would be just bothering the court with something which is not the issue involved. I read out, Lordship, page 25, quoting 29(1)(b).
Page 25?
25 annexure 2, my affidavit, Lordship. Lordship, if I may just take again to page 25.
Yes.
Lordship, we have specifically quoted 29(1)(b) and rule 29(4)(d).
No, but he said this one's been set aside.
No, not this one. Not this one. Office memorandum, my lord. Lordship, we don't have to venture out to office memorandum because
memorandum doesn't satisfy.
We don't have to venture out, Lordship. We have to confine an argument within the parameter of 29(1)(b) and 29(4)(d). Lordship, had it been the case on facts, that we have also invoked 29(1)(b) and 29(1)(b) and C and 29(4)(d), the second part. Maybe then the different case could have built out. Now, if you come back, Lordship, to 29(1)(b) again, just for the 29(1)(b), just to answer the issue raised by my friend.
Yes.
His argument, Lordship, is that date of appointment should be considered.
Yes.
Let us first come to 29(1)(b). The inter se seniority.
Yes.
So now, if this word was not there, Lordship, then maybe we could have again ventured out something. But the word is the inter se seniority of lower division assistant mentioned in clause B of rule 3(1). Shall be. It's not maybe.
Exactly.
shall
That
be
is what
in
the
order.
question put to. Someone said because the rules are a bar to you for. But then whether
Lordship, I
like,
don't want-
whether
I
the
don't-
date of
I-
appointment
I-
will play, will go against settled law. That is the only thing.
Lordship, that would be, Lordship, I didn't want to burden the court. Otherwise, we could have gone on length to ask for a legal constitutional argument or whether this has to be declared. Had it been the case to declare this as 29(1)(b) and C ultra virus,
Yes.
we would have presented a different argument. How, Lordship? Then maybe he would have had to build up a different case. No, our case is clearly that. So for the list which is concerned, MPSC list, in that what is their seriality? Whether that is protected under 29(1)(b). My limited argument with Lordship, it comes within the four corner of 21(1)(b).
Right. But I mean, it can be disregarded. Like the date of appointment, he's not born like adult also. Can he be considered senior?
Lordship,
Irrespective of.
Lordship, that's why I use the language of the legislature, Lordship, is the inter se seniority. Had this word not been there, then we could have gone for interpretation. Then maybe we would have recommended. But it's clearly specific. The inter se seniority will be as per the list prepared in the merit. And they are clearly, his position is very clearly laid down. He's number 68. So the issue.
There's no issue.
There is no issue with that. Lordship, my submission would be that we can't venture out.
He's confining his arguments to the date that I was appointed before that, but maybe a month or two.
Lordship, I'm afraid, Lordship, that cannot be his case.
Why?
Because if he would have invoked C, and the case would have come within the meaning of C, and that is, the case is yet to come. It's still born, Lordship. The case starts and ends. So for government is concerned, it starts at 21B, and it ends there because the list from MPSC comes. The moment list comes to us, Lordship, 21B is exhausted. Now we are confined to the order of merit of the MPSC list, and in confining that, we have appointed. The date of appointment will be irrespective, Lordship, depends upon a vacancy. That is not the issue involved. The issue involved in 29(1)(c) is to confine within the merit of MPSC.
Anyway. Yes.
So, Lordship, my reply would be the argument for my friend is unsustainable, Lordship, because there is neither his case in the pleading, nor he is relying on any judgment, and we have not invoked B. Had it been the case, had we invoked B, then we had to answer that. Since we have not invoked B, Lordship, it's nobody's case.
Invoke B only.
29C, sorry. 29(1)(c), since we have not invoked 29(1)(c), so it's nobody's case, Lordship, the date of appointment. And as I submit, Lordship, if I conclude my argument, Lordship, 29(1)(c), Lordship,
yes,
as my colleague from the private respondent rightly said, that would have been the case if respondent number 4 was still contesting the case, and then we would have gone to the date of appointment. So that is a closed chapter, and it's only a particular cadre of direct recruits. And within direct recruits, it's 29(1)(b), which is at play within the four corner of MPSC results. There is no merit in the case.
Lordship.
Yes.
Just to rebut what my senior submitted, my lord, when a rule is being read, it has to be read in entirety, my lord. So here in Rule C also, it talks about inter se seniority of the assistant appointed under clause B and C of Rule 1 of Rule 3. It talks about B as well, my lord. If Lordship can see the inter se seniority of the assistant, my clause C, my lord. Page 10.
Lordship, can I hurriedly answer that? If you just come to 3 on page 2.
So the inter se seniority,
all the more reason
if I may be,
Lordship, all the more reason that he's supporting. Okay, please.
The inter se seniority of the assistants appointed under clauses B and C of Rule 1 of Rule 3 shall be according to the dates of appointment. Talks about date of appointment, my lord. Even if they are appointed under clause B and clause C.
Lordship, hurriedly,
then also
reply.
date of appointment has to be taken into consideration, my lord.
B and C is to deal with that situation where B and C is retrenched person so absorbed in Parliament government.
C was never set into motion, Your Lordship. It's not the case that C also has been set into motion. 3(1)(c). 3(1)(c). Only B. The situation will arise only when
my argument is confined only
when you consider other people.
Yes.
Like who are from outside your cadre.
Lordship.
When you have to consider
then date of appointment.
Then the appointment comes. Suppose some promotees
but it doesn't say in between, my lord. It talks about and. The word and is there, my lord.
Yes, and
that is what, my lord.
Them is the interest notice and
clauses B and C of Rule 3, my lord.
Yes.
Shall be according to the dates of appointment.
Under clause B and C. Correct. So BNC means those who are BNC, if you make a communication list for them, that means it should be according to date of appointment.
Your Lordship, if it was...
You're confined to
only
you're confined to B only. You are people who came to come to
there
the
is no
exam.
facts, Your Lordship.
And the rule, I do not know how correct it is, has
a different story,
limited, the seniority to only, but that is also very questionable. If you can get some authority, I'll give you 2 days time. Get some authority to say that not the rules also, the appointment will be will hold. Just look at that, Mr. General, also. It's interesting. We'll sit on Wednesday.
Lordship.
Wednesday.
Lordship was referring to a judgment that was, this is a decision by this court, Lordship, and Andrew Shabong.
Yes, what does it say?
Oh, Lordship, we can't read it. We'll maybe after tomorrow, we'll give a copy. But I can just give a reference, Lordship. Andrew Shabong versus decided on 30 January 2023. WPC 250 of 2020.
That's regard to date appointment, merit list and date appointment.
Retrospective.
No, not Andrew Shabong. There's not the case. It's an excise matter.
Not aware,
I think, I don't know.
Any
much I might remember.
Lordship will
I can't recall. Yes.
Lordship, after 2 days, let him come with the judgment. Our response will be, Lordship, in the absence of challenging the rules itself. Whether
yes, day after tomorrow.
Lordship, a small request. Instead of Wednesday, can it be on Thursday, if that is convenient?
Lordship, I don't want to slip into off the continental shelf.
Not in this one.
Look for a Titanic and implode. So that's the thing.
Can it be on Friday, my Lordship?
Friday, this court is touring.
Lordship. Lordship, okay, my Lordship. Hello, Lordship.
Today's 10th. Are there any ready matters at 2? Or 3 matters are there, yes.
But I crave my Lord's indulgence. But I'm thankful to my friend Mr. Abraham for making a mention before this Honorable Court, item 29, my Lord. But he had also made a prayer for extension of stay. My Lord, that will not be required, my Lord. Because there is already an order.
For other things. Because you didn't give him the file, how do you know who
Please, Lordship, this item number 37. Actually, I probably responded. It may come after some time, maybe some. Petitioner is here, actually. Because
don't break the desk. No, so just joking. 37.
Lordship.
35?
35 is
35 will be next week, your Lordship. Lordship, this is a pension matter, Lordship. For 11 months, we have been deprived of.
Oh, GCDC?
Yes, Lordship.
Any chance of getting pension in the next 11 months also?
This is counsel to tell your Lordship.
Next week, you know.
Next week we'll have legislation.
Lordship, if possible on Monday, your Lordship.
Monday is holiday, if I'm...
Unless Kirat Singh is...
Tuesday, your Lordship.
Tuesday, okay.
Apply, your Lordship.
Yeah, one matter, what's there? This Mr. Mansuri.
Sorry, your Lordship. Let it be on Wednesday, your Lordship.
19.
Whatever. Yes. 33?
32, your Lordship. 33. Yes.
Where does the matter stand? Connection of light?
No, the electricity has been restored,
Your
Lordship. So, matter of concern is I want to make further submission to the observation made by the court.
Regarding?
The judgment in miscible appeal. This is matter related to section 151 CPC.
Nothing remains.
There is nothing, no remark has been made by the learned appellate court.
There are remarks.
Regarding?
The court has overstepped its jurisdiction, and there are controversies and issues which needs to be decided in a
When was the
trial court.
restored? It's been restored recently.
My lord.
Well,
No,
long
recently,
time back.
madam. It's been a long time back.
Long time back.
They have come before this court filing a second appeal, my lord, against the order passed by the appellate court.
Because you kept on filing 151 applications.
Yes.
You kept on filing 151 applications.
I
correct?
filed that elected.
You didn't file a statement also.
I filed. Written statement, show cause, everything has been filed, my lord.
We have filed objection because there has not prayed for any enlargement of time.
No, that is subsequent. If they have filed now, that is subsequently after 2 years. If they file an objection.
Oh, you take a date, then we'll hear it.
Yes,
we'll hear it finally. I did. Let them choose a date. I request the parties also. This is matter also as a fixed matter. We'll hear it. No point to it. Yes.